Good morning, everybody. Happy Monday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through the next 3 hours of our journey through Courtlandia. But before we get started, today marks 13 months as a channel member for Barbara and 12 months as a channel member for Lindsay. And I just wanted to take a second and thank both of you for all of your support. It's really appreciated. It's humbling that you people stick with me for so long. So thank you so much. With that having been said, let's find our mouse. There it is. Let's get started with our favorite magistrate, Magistrate Chisholm.
This is 26 RO 01648. Ms. Kocher, you were cited on March 24th at 9 o'clock in the evening in the area of Royal Oak near Woodward and Webster for not having a valid registration certificate. You can admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
Admit with an explanation.
And what is that, please?
I received the renewal notice from the Secretary of State for the car I owned previous to the one I had. And when I got a new lease in July, I just simply forgot that I would need to renew my license plate in September. And I truly forgot. That's the best explanation that I can give you. I think I was in shock when I realized I had let 6 months go by.
When did you get the new one?
July like 20th or something like that.
No, I don't mean the new car, the new plate.
Oh, the minute I left the officer, I drove straight to Meyer and used the self-serve kiosk and renewed my plates that day.
Is there anything you want to add to this, officer?
Yes, Your Honor. I looked up the plate and it is up to date, so I'm okay with the dismissal.
Okay. Ms. Kocher, we're going to take what the officer said as a motion to dismiss. And you are good to go. The ticket is dismissed. Thank you.
Thank you very much. Have a great day.
You too.
Thanks.
Well, he's between contestants. Tim, thank you for 4 months of being a channel member. And Wahoo, thank you for 8. Very much appreciate the two of you as well. Thank you so much.
They're all up to date.
And the next one is not an expired plate ticket. So let's see how we get on that.
Good morning.
Good morning. This is ticket 26 RO 01729. You were ticketed on March 28th, almost 8 o'clock in the evening in Royal Oak near Lincoln and Maine for disobeying a traffic signal. You've got 3 options this morning. You can admit responsibility, you can deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed this morning?
I wish to the number 2.
Number 2 is to deny.
Yes, sir.
Okay.
Yes, Judge.
And then if you would raise your right hand to take the oath so we can begin the hearing.
Oh, okay. Sorry.
Do you swear or affirm that the testimony you're about to give in this matter will be the truth?
Yes.
Yes.
Okay, the officer will testify first, please.
Your Honor, the date and time listed at the citation. At the location of Maine and Lincoln, I noticed Miss Davis' vehicle run through and go through the light. And I pulled her over for the traffic. I do remember Miss Davis, I did not receive a subpoena for today, so I did not review any of the dash cam footage or any part of the citation. So I am okay with just dismissing for today since I was not prepared.
Ms. Davis, it doesn't get better than that.
It do not.
Pursuant to the officer's motion to dismiss, ticket is dismissed. You are good to go, man.
Thank you. You guys have a good day.
You too.
Thanks.
First person in the waiting room I don't see on the docket, so we'll go to Missouri. Missouri, if you would unmute yourself, please.
Can you hear me?
Yeah, we can.
Okay, thank you.
This is 26 RO 1733. This ticket was issued on March 28th, 8:49 in the evening, Woodward and 10 Mile area, Royal Oak, for driving on expired plates.
Yes.
The officer has already indicated that you renewed the plates, and she has moved to dismiss the ticket. So glad you appeared, but you are good to go. The ticket is being dismissed.
Okay, thank you. No fee. I don't have to pay a fee or anything either.
You are good to go.
Okay, thank you. Enjoy your day. Thank you.
You too.
Bye-bye.
At Mr. Praviti. This is citation 26 RO 01754. Mr. Praviti, you were cited on the 29th of March, 12:43 in the morning in the area of Royal Oak near Main and 4th Streets for operating while using a mobile electronic device. You can either admit or deny responsibility, or you can admit responsibility with an explanation. How do you wish to proceed?
I would like to admit responsibility with an explanation.
What is that, please?
So I was, I haven't been driving for super long, and I don't very oftenly take phone calls while I'm in the car. I was not using the phone in any fashion. I just had it against my ear. And I wasn't aware that the law was hands-free. I've since then researched into it and read it through, so I understand. I've gotten a car holder that's legal for future GPS usage or anything like that. And I guess I also I'm not 100% sure how fines work per district, but the first offense for that law was put at $100. I don't know. I couldn't find anything about like if districts apply certain costs after the fact, or
When you see the signs that say, for example, speeding tickets doubled in school zones, the fine is doubled, not the whole cost, because there's a fine and then there's costs.
okay.
So the total expense with this citation is $220. However, there's no points for this.
Yeah.
Now, when they do the research on hands-free and hand handheld communication devices shows that once the conversation is going, they are both about equally distracting.
Hmm.
But the distraction caused by the use of the hands in dialing makes it much more dangerous than just talking to your dashboard kind of thing. But the actual conversation is pretty much the same. If you're talking with a passenger, that can also be distracting, but then you have the benefit of the passenger's reaction to the danger the driver might not be seeing as fast as the passenger does. People that are operating on the very first license you get before you have a full license, they can't use a phone in any way, hands-free or hands held. It's just off the table because it is distracting. Now, I don't know that holding a phone that is more distracting than holding a hamburger, but that is what the law is. Now, there's no points for this yet, but the fine is $220, and you can pay it online or by mail, or you can pay it at the courthouse counter if that's more convenient for you.
Yeah, if I may, I knew that there was no points attached. I was just looking to, if possible, come here today just to plead with the court that it be reduced in some fashion, if possible.
Well, I can give you time to pay if you need time to pay.
Yeah, that would help.
What kind of time do you need, sir?
At least a month would be okay.
I can go 30 days.
Okay.
And that can be paid online or by mail or at the counter, whatever works for you.
Absolutely.
30 days to pay. Thank you.
Okay, thank you.
Bye-bye.
So good morning once again, everybody. It's TCF Live on a Monday. Good to have you all here with me this morning. Let's go to Huron County, Michigan. This is Judge Prill, and this is the case of Terry Kaufman.
This is file number 267390 at 8 time and date set for sentencing. Appearing on behalf of the defendant is Elizabeth B. Weisenbach, and from the Attorney General's office, sir, could we have your name for the record?
Michael Trescone, Your Honor.
Please spell your last name, sir.
Trescone.
Thank you, Mr. Trescone. This is time and date set for sentencing for the defendant in this matter. Ms. Weisenbach, where's your client?
Thank you, Your Honor. My client is not with me at this point. I received a call and I have since received a text message from his wife that he is at the hospital.
Mr. Trescone, do you have any response?
Your Honor, the people tried to meet with Mr. Kaufman before the case was filed in an attempt to resolve this pre-charge. Every time we set up a meeting with Mr. Kaufman, he canceled the meeting the morning of because he was in the hospital. This seems to be the game that he plays to avoid responsibility, and the people are requesting a bench warrant.
Ms. Weisenbach, any response?
I have no reason to disbelieve his wife. There is nothing in this record or any reason whatsoever to doubt her truthfulness with regards to the matter. If that's where he is, that's where he is.
All right. Well, for the record, we did have a brief conversation off the record regarding this matter. The court was advised that the defendant is unavailable, and at least at this point, and the Attorney General's office has placed on the record exactly what was stated during our conversation. And as a result of that, this matter is scheduled for 9 a.m. The defendant is not here. He has until 9:30 this morning to appear. If he fails to appear in this matter, the court is going to issue a bench warrant for his arrest, body bond. And that was discussed as well in chambers as well, Ms. Weisenbach.
I just want to let the court know that is agreed. I want to let the court know that I could probably be available until 11 o'clock. I have 2 other matters, and I do need to meet with an individual whom I am substituting for different attorneys, so that would take some time. So I can be here until 11 o'clock.
All right.
And Your Honor, if I may, if the court would provide a paper copy of the warrant at 9:30, I have my special agent here in person who plans to go directly and arrest Mr. Kaufman.
Very well. We'll try to get that done as quickly as possible.
Thank you.
we'll adjourn, I should say, we'll go off the record and we'll recall this case around 9:30 or so.
Thank you.
Thank you, Your Honor.
Well, that's taken a twist. Just as a reminder for anybody, Terry Kaufman was the guy up in the thumb of Michigan who was the funeral director who basically took everybody's money and provided no services. What was it, like 200 people he defrauded or something to that effect, over $1 million as I recall. So that has taken a definite twist. So I will try to keep an eye on that while we are live here during our 3 or so hours, and I'll keep you updated as I can. Let's go back to, let's go back to Magistrate Chisholm.
I admit responsibility with an explanation.
What is that explanation, please?
So I'm an interventional cardiologist. I know this is not an excuse, but I was driving. One of my patients, his heart stopped. So I was just driving to be able to get there on time. I work in Royal Oak Hospital, so it was 2 a.m. They called me, they said his heart stopped. So I was trying to rush to the hospital just to get there on time.
On time for what?
To take him to the cath lab to do the procedure for him. His heart stopped.
But he was still being cared for by physicians, was he not?
He was in the emergency department, but we have to, when the heart stops, heart attack, I have to take him to the cath lab and open his arteries. So yes, he was taken care of by other physicians, but it's time is essence for the muscle. If we don't get by within 20 minutes to him, his heart doesn't come back.
Is there anything you want to add to this, officer?
Yes, Your Honor. I know I iterated this to him on the stop. I had to go over 90 miles per hour to catch up to him after he passed me. I did a U-turn in the middle of the road, did over 90 to catch up to him. He lives in Royal Oak, so I know he knows that the speed limit on 13 miles, 35. And I also, just to reiterate, in the future, I know you work at the hospital. I get it. You got patients to save, but they're not by themselves at the hospital. And if you don't make it to the hospital because you're doing 90 and a drunk driver pulls out in front of you, or a pedestrian starts walking across the roadway and you hit somebody and you die, then your patient's not going to live either. So just keep that in mind. Sometimes we're going fast as an officer because we got, emergencies to go to. You're not paying attention and you hit one of us, that's even worse. Like there's different circumstances, especially in the middle of the night. And I believe, if I'm not mistaken, the night that I pulled you over was like a Friday or Saturday night. And in Royal Oak, that's a really dangerous night to be going fast in the area just because we do have a lot of drunk drivers, unfortunately. So I get it. I go to emergencies too, but there's a reason why we have lights and sirens and you don't. So just keep that in mind while you're going down 13 miles, because I would hate to see, a physician getting in an accident trying to save their patient, but they were being reckless on the way there. So just keep that in mind. And I could have done a lot more on the stop too. I could have taken your car. You could have gotten a misdemeanor. It could have been a lot worse in many different ways. So just please be more mindful in the fact that we are out there. Teenagers are out there, drunk drivers are out there, and I would hate to see something to happen to you or somebody else because someone's not being responsible on the road. So just to reiterate, I did give you quite a big break that night as well.
The other factor too is that increasing the speed doesn't change the time that you arrive by very much at all. On a 25-mile city suburban course, if somebody drives as fast as they can for 25 miles, they drive as fast as they can, but they stop for the lights. City suburban, they'll save 2.5 minutes in 25 miles. So it really doesn't get you there faster. It seems like you're getting there faster, but it really doesn't amount to much time. The other side of the coin is to the points. Given your record, the Secretary of State is going to give you an opportunity before the points go onto your record to take an online traffic safety class to avoid the points. The fine is $170. It can be paid online or by mail, or you could pay it at the courthouse counter if you like. The Secretary of State does not assess the points until after you've had the opportunity to take the class that the Secretary of State will send you the information on. You don't need to do anything to initiate that process. As long as your address on your license is the address where you reside, you'll get the mail from the Secretary of State. So that's $170 and still the possibility of no points. Had the officer written you for 1 mile an hour faster, you would not have been eligible for that program. Thank you. Have a good day.
So this half hour of TCF brought to you by Doc Dash. Do you need a doctor in a hurry? Just simply get on the app, summon up a doctor via Doc Dash. They will drive 90 plus miles an hour in a 35 to get to you. Will they kill people along the way? Maybe, but they will save your life. Doc Dash. You can find it in the Google App Store or the Apple App Store or any of your favorite app stores. Thank you so much, Doc Dash, for sponsoring this half hour. Let's go to Judge McNally.
146691B, 25W39353, 25W38256, 25W38387175, and T5F244556. Your name? All right, I took your plea on the April 14th case. You had a lawyer at all of this, didn't you?
Yep.
Who's your lawyer?
I forgot the guy's name, but it was the guy in the room to the left.
Oh. It was Mr. Haynes last time, it looks like.
Is he here today?
He's not.
No, we have Mr. Graziani now.
You have to go.
They're sitting all the way.
So you can have a seat out there and bring all the files to him, okay? We had a change of the lawyers after a few months here. People against. Megan Crystal Clark, 26F246036. Good morning, ma'am.
Hi,
How are you? Your name?
Megan Clark.
All right. You're getting close to not having one of these accepted. You understand that, right? All right. You want to plead to impeding traffic? Is that what you're going to do? To that charge, responsible or not responsible?
Responsible.
All right. Fines cost $175
Okay,
and you are all set.
thank you so much.
Okay, and I'm going to dismiss the speeding. Slow down though, please, okay?
Thank you so much.
Have a great day. Thank you. Patricia Christine Sanders, 26 F246101. Good morning, ma'am. Your name?
Patricia Christine Sanders.
All right, you are going to plead to impeding traffic, correct?
Correct.
To that charge, responsible or not responsible?
Responsible.
Were you cited on this failure to stop assured clear distance back in March? Do you have any other tickets?
I had that
Over up here.
accident that I was turning into Panera and
Did you get a ticket? Did you get
Yes.
impeding?
yes,
So you gotta be careful. You had 2 in 2 weeks, right? And you had a failure to yield in December of 25, right?
yes,
Gotta be careful.
I know,
To the charge impeding traffic, responsible or not responsible?
responsible.
Okay, I'm gonna accept your plea. Do you still live in St. Helen?
I own the house up there, but I've been down here 3 years because I tore up my arm and that and still trying to get my arm back at my sister's.
All right, I'll accept the plea. Dismiss the speeding 175, okay?
Thank you, sir.
You're all set. Cashier into the hall to your right. Tatiana Sanchez. 26F 246015. Hey, Sadie? I would check here instead of here. I'll check here. I'll date that here. If it's set, has to be set for an informal, okay? Your name?
Tatiana.
All right, good morning to you. You met with a department rep and you're going to plead to impeding traffic, correct? To that charge, responsible or not responsible? You got a clean record. I'll accept the plea. 150 is your total and you are all set. Okay? Have a good day. Thank you. Morning. So how was the course yesterday?
Really nice.
Oh,
no, you know what?
The area even,
Yeah.
but they're not as bad as they were on Wednesday. I'll tell you. Oh, yeah, they did them last Monday, so every day they'll get. Morning there, Lieutenant.
Morning, your honor. It's great.
Yeah, I know.
Yeah. Judge, you got a minute?
Sure. Sergeant, good morning.
Morning, your honor.
How are you?
Good, how are you?
Not bad.
First of all, I was still no way. Yeah.
She got an attorney?
She is a. Yes. Take it on the way.
You went to 5, speed 1 to 5 over, so it's.
She was spoke to me a little bit, said she's.
He's got some nerve better.
Oh, it is, okay.
I don't know.
Is it? Oh, yeah. I wasn't really impressed with it. You want to get dismissed? I said, I thought, do they think that that's the case? Okay, I just didn't know if there was something. I didn't think that that was
No.
the case. All right.
Shannon Lynn Clark, 267-245-996. How you doing? Good. Nice to see a smiling face in here. You're going to plead to impeding traffic, right? You have insurance?
I do.
All right. Okay. All right. To the charge of impeding traffic, responsible or not responsible? Okay. I'm going to accept your plea. You're going to slow down because you're going 51 and a 25, right? 150 is your total. Good luck. Slow down. Have a great day. Thank you. I don't know if I'm pronouncing this correctly. Taihavo, Tangween, 261-50790. Your name? Good morning, sir. You're going to plead to impeding?
Huh?
You're going to plead to impeding traffic?
Yes.
To that charge, responsible or not responsible? You plead responsible to impeding traffic at 0 points. It won't go on your record.
Yes.
All right, please accepted, 150. You are all set. Have a good day. Thank you. So this is the line I'm talking about. And then the only time I'm gonna write anything is if I have to set up the informal or something. You're all set, sir. Have a good day.
Thank you.
What is your name back there? Alcantara?
John Ware Company.
Is that him? Who's John Well Alcantara?
He don't speak,
It says he doesn't speak English. Do you? Come on up here.
Come on, Chris, look what it.
Come on up, man. You're all set. All right. Okay. Do you speak good English? Do you speak good English?
I can try to learn. I'm always help you.
What language do you speak and what language does,
Spanish.
and does he speak Spanish?
Yeah.
All right. You understand what I just said to you?
Yeah.
This says, can you help me out and tell him that this says he's going to plead to speeding 1 to 5 over? Do you understand that? Can you tell him that in Spanish?
Yeah.
You have to tell him that. Are you going to tell him?
Yeah. I will tell you.
Oh, tell him now. Tell him this says he's going to plead to speeding 1 to 5 over.
No, estaba haciendo un giro hacia.
Wait. that what he, no, wait a minute. I'll get an interpreter, have to have him come back if you want. I don't want to have to do that to him. But I don't want to hear his story right now.
Okay.
I have a stipulated agreement that says, it says he's going to plead the 1 to 5 over.
Yeah,
Tell him that. Is that what he wants to do? Ask him if that's what he wants to do, is plead the 1 to 5 over. Yes or no? Yes or no?
Yes, Chisholm.
Is that, I want to make sure here, help me out now. What's your name?
I'm Walker.
Can you spell your name for me?
Yeah, ARNEY. Walker. WL.
WALKER? All right. Ask him if that's what he wants to do, is plead the 1 to 5 over. That's 1 point. It will go on his record. Tell him that. Is that what you want to do, sir? Tell him that, man. You gotta help me out here.
Yes, sir.
All right. Ask him to the charge of ask him this, to the charge of 1 to 5 miles over the speed limit. How do you wish to plead? Responsible or not responsible? Ask him that for me.
No, sir.
He don't have that charge about high speed. It's just for long drive over the 23. Tw- 23.
Listen. If I have to adjourn this and get a Spanish interpreter, do we have a Spanish interpreter coming in the next few days? Heather?
I don't think so off the top of my head. Let me look and see when I have Evelyn come, if I have her coming next.
Are you understanding me?
Yeah. So
Oh, actually, Judge, we do on the 14th. Evelyn's going to be here for a sentencing.
I have to adjourn this to the 14th. I have to adjourn this to the 14th. So we're gonna adjourn this 3 days. Okay?
And Evelyn will be
And
here at 8:30
and I'll-
that day.
I'll honor this plea agreement. What time are they gonna be in here, Heather?
8:30.
Good. Will you send them right in? Be here at 8:30 in the morning on the 14th. Okay?
I'll do
All
a
right.
notice for them, Judge, if they want to come down and get it.
You go down the hall and they'll give you a paper notice, okay? Do you understand that? They'll give you a piece of paper. 3 days later, you have to be in here on Thursday, the 14th of May, okay? We'll have an interpreter. It'll be a lot easier, all right? Okay, thank you both.
Alrighty, friends, good morning once again. TCF Live. It's a Monday. It's nice to have all of you here with me this morning. If you haven't done so yet, say good morning in the chat. Love to hear from you. Let's go back to Judge Prill, new contestant there.
Second, file number 23, 6983 and 26, 7411 F. Time and date set for sentencing. In both matters, the defendant is present, represented by attorney Elizabeth V. Weisenbach. The people are represented by prosecuting attorney Timothy J. Witkowski. In the newest file, the defendant had pled to prohibit weapons possession. There was a probation violation in the old file as well. The plea on the prohibited weapons charge was on March 16th of this year. Ms. Karen Everland prepared the pre-sentence report. It's dated April 27th. Ms. Weisenbach, have you and your client had the opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
No.
Any objections to the guidelines?
No.
Mr. Hiltz, do you agree with all that?
Yes.
And Mr. Witkowski, any objection to the report as well as guidelines?
No, Your Honor.
Thank you. Ms. Weisenbach, anything you'd like to say on behalf of your client before the court imposes a sentence?
Thank you, Your Honor. Mr. Hiltz comes before the court, 42 years old, and almost his entire criminal record is based upon alcohol. He's an alcoholic and he knows it, his family knows it. Despite that, he is a good dad, and you have, I believe, received letters from 2 individuals, his former, well, his mother of his daughter and her current husband. That says a lot. That's its own message, that those people thought enough of him to write letters, and they did. They're not half-page, half-hearted, yeah, we know him. It's 2 pages each about what a dad he is, the dad, and how he's involved with his daughter, and how a long explanation of Huntington's. I know someone personally who I used to chase when I was a prosecutor, and her mother died of Huntington's, and now she is in her early 40s and she is dying of Huntington's. I get that. And so to impress upon the court that that is a serious matter. But I will tell you this, he has kept that private, and I was not aware of it. It doesn't show up anywhere else, because some stuff is just not everybody's business. But they felt it was important to come forward for their daughter, stepdaughter, her daughter, to say to this court the things that they did in their letters. Excuse me. The symptoms have started to set in for my client, and no matter how he tries to control it, it's on its own track. It is a disease that just starts and it goes. I'd like to give a couple of quotes from the letters that we had received. As Mr. I believe it's Bullet points out, Huntington's disease is incurable and ultimately fatal. And Nicole Johnson's letter says it the absolute best, in my opinion. 2nd page, third full paragraph, 4th chunk. I am not asking that there be no consequences. I understand that there must be. I am simply asking, with as much sincerity as I can express, that the court consider whether there is a way to hold Charles accountable while still allowing him some presence in his daughter's lives during what may be a very limited window of time. These are decent people, good people. They care about their daughter. They asked, and by the way, Mr. Hiltz had no idea these letters were coming about. They contacted me directly and asked how to send these to you. They are asking for a solution that meets both of the court's objectives and their daughter's time with their father, because it's going to be limited. I would recommend some kind of a split. If the court were to sentence him, in one of the recommendations, it's 365 days less 182, which is 6 months. 1 year turns into 6 months. So I would recommend to the court utilizing that 6 months as a sentence. And that is a solution that makes time for the daughter, and it gives the court the opportunity to punish my client. He knows he didn't do the community service. He knows there was counseling and things that needed to be done, but he also knew all along that he was an alcoholic. That was not going to, that just wasn't going to change, as nor is the Huntington's. So I'd ask the court to split the difference, give them what they have asked for on behalf of that daughter and all of his children, and the court gets its objective with regards to punishment.
What about the firearms charge?
He's had those before, as the court confused at least one, and
How many
it took
times
all of
has the court stated in any probation order, you must not use or possess or have in your possession any firearms, not to be around anyone that possesses those items? That was given to you.
understood. At the same time, this firearms charge has nothing to do with using a gun, it being in the wrong place, hurting anybody. It was just there. That was it. It was just there. And I would assert to the court that sends his own message as well. He wasn't hunting. He wasn't anything.
2 firearms, not just one.
I understand. I know these things, Your Honor. I am here because good people came forward to give a lot of private personal information on YouTube to get some time for their daughters. Well, their daughter and the other children, I guess. They approached me. This was not from him. Thank you, Your Honor.
Does your client wish to address it?
Yes, sir.
Go ahead, sir.
I would like to appreciate you taking time, listen to a little bit about the story. I appreciate that. Listening to them. Good people.
Anything else?
No, sir.
Thank you. Mr. Rutkowski, on behalf of the people.
Your Honor, this is an Operation Nighthawk case, and as the court has pointed out in the past, it shows that there is teeth behind the probationary order because adult probation is out there and they've been doing these things and they've uncovered different things, such as this case. The guidelines on this are 7 to 28. So with that guideline range, Ms. Weisenbach's asking for 6 months, but that's below the guidelines. And there is absolutely no reason to go below the guidelines on this matter. The fact is that Mr. Hiltz knew he shouldn't possess firearm and had 2 firearms on him. He's got 2 prior felonies and 22 prior misdemeanors. So we would ask the court to fashion a fair and just sentence. We recognize that the recommendation is 365 days, but the court also can see fit to stay within that guideline range, whatever it sees fit.
Thank you. As stated, Mr. Hiltz comes before the court, 2 prior felonies, 22 prior misdemeanors, 42 years of age, 12th grade education, and employed. He was on probation to this court for operating while intoxicated, 3rd offense. And Operation Nighthawk, which the court has been mentioning a number of times over the course of about a year and a half, is a program where the Michigan Department of Corrections adult probation will go out in the evening and check on probation to see whether or not they're towing the line. Now, there's some other counties that don't engage in that, and that's fine, but Huron County does. And the court embraces it because probation is a grace. Probation is an opportunity to better oneself so that at the end of the day, they learn, individuals learn from bad choices and don't re-engage in the type of behavior. Everyone has to toe the line. Sadly, Nighthawk has produced a number of people before this court. We are going to have another sentencing here later this morning involving another Nighthawk matter. And it just goes to show that while you're on probation, you have to follow the rules. If you fail to follow the rules, there are consequences for it. And certainly the court did review the letters that have been presented. They were presented to the court back on May 4th. The court reviewed those letters and they're moving. There's no question about that. So the court considers that, but you also have to consider the behavior. And when a court sentences an individual to a felony, the number one, other than obviously the other terms, the number one thing is you are not to possess or use a firearm, have anything in your possession. You can't even be around individuals that possess those items. And in this case, 2 shotguns were found. They weren't used. I agree with Ms. Weisenbach. They weren't used in the commission of a felony, but when you are a felon, there are certain things you cannot do. So the court has to consider that. The court has to consider also at the time when police, or I should say police, when Nighthawk folks contacted Mr. Hiltz, his blood alcohol level is 0.112. On probation for operating while intoxicated. Give him credit for not being behind the wheel, but he was consuming alcohol. And he acknowledges there's issues relative to alcohol, and the court has to consider that as well. So a lot to think about here, but it will be the sentence of this court on the probation violation. Guideline range originally was 0 to 17, which would call normally for a jail sentence. And it will be the sentence of this court that probation is unsuccessfully discharged, or the defendant is unsuccessfully discharged from probation. All monetary obligations still remain due and payable. And as a matter of fact, he's paid everything. So I give him credit for that. But it will be the sentence of this court that he served 365 days in the county jail, credit for 182 days previously served. Relative to the new charge, that is the possession of a firearm, in this case 2 firearms, will be the sentence of this court. The defendant pay a crime victims assessment of $130, court cost of $200, payable at the rate of $20 a month, a fine of $200, payable at the rate of $20 a month. Attorney fees are waived. $68 in state costs will be ordered. The firearms will be forfeited to the Bad Axe Police Department for disposition, and it will be the sentence of the court that the defendant serves 365 days in the county jail, credit for 1 day previously served. The first 7 months minus 1 day, so the 1 day credit. The first 7 months to be served up front. The remaining remaining time frame left will be held in abeyance. The reason the court is doing that is based upon there are health concerns, and it's clearly documented, and it's clearly another concern the court has because we have to balance the medical concerns of the defendant. We also have to consider the cost of the county relative to providing services for the defendant if he's lodged in the county jail. So there's a balance there, and the court has to look at that. But the remaining jail time will be held in abeyance, and if he successfully does everything he's supposed to be doing, follows through, remaining time will be held in abeyance. But if there's a problem or an issue, he's going to serve the remainder of that full year. The sentences also under law shall be served concurrently. It's my duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, court will assign counsel for him at public expense. He's to initially receive the questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court within 42 days. Court has no objection to word release so long as it is comporting with the Sheriff's Department guidelines. Mr. Rukowski.
Ms. Weisbach, can I approach?
Pardon me?
Can we approach?
Yes. Wait. As stated, there's no objection to PA 511 status. The reason, and just so that everyone is clear, because probation would be saying, well, what about the remaining time in the event there's a problem? Well, he's placed on work release. They test every time he comes back to the jail. There's alcohol in his breath, anything in his system that's not supposed to be, then the jail time will be served forthwith. So that'll be all. Good luck to you. You remain in custody of the sheriff. Off the record.
So good morning once again, everybody. It's TCF Live on a Monday, about 45 minutes in already. Time is flying. So a couple of things before we move to the next court. Judge Prill referenced Nighthawk. So specifically in Michigan, this is Operation Nighthawk. It's a high-intensity, unannounced compliance check targeting parolees and probationers. It's run by the Michigan State Police and local law enforcement. It's conducted after hours. The sweeps are intended to verify curfew compliance, check for drugs and alcohol, and enforce probation conditions to reduce crime. So I wanted to bring everybody up to speed on what he was talking about, because he also referenced that they were going to have another case with that today. I don't know if we'll see that case or not, but if we do, now we know what he's talking about. And I also wanted to share this from Lindsay. She posted this over in the community tab, but not everybody goes to the community tab. She's celebrating her 1-year channel membership today. And again, thank you for that, Lindsay. But she says, to say the last year has been a tough one would be an understatement. However, the consistent bright spot has been this channel, this community. Knowing this group is here, hi Ellie. This group is here with and for me has meant more than you know. Here's to laughs, the learning, and the love. Thank you, Dan, and the entire Soul family for all you do in providing this amazing space to come together. Thank you to the Sidebar panel for being smart and hilarious group of humans you are. Thank you for the Mod Squad for always being there and keeping this comfortable space for everyone. Thank you, Ellie, for just reducing every single panel. She's keyboard crazy. Thanks to all the members for encouraging me to share the hilarity of my home county, and thank you to all the subscribers for being the best community on the internet and for giving me a wonderful space to spend my mornings. Love to all. Here's to the next year. So thank you for that, Lindsay, and thank you for everything you do for us. It's very much appreciated. So let's go down to Florida and Judge Mercer while I figure out what Ellie did to my computer and try to bring back all the windows that she just closed.
We do have some individuals that may need the services of an interpreter. Is this Mr. Lopez, Mr. McDaniel?
This is Vincent Lopez, correct?
Mr. Ricardo, if you please introduce yourself to all four of the individuals, all of the individuals that may use an interpreter this morning, please.
Muy buenos días a todos los individuos que quizás usen un intérprete esta mañana. Mi nombre es Jordani Ricardo, intérprete para que se puedan comunicar con el juez. Quiero verificar que ustedes me vean y me escuchen bien.
The first case is State versus Vicente Lopez.
El primer caso es el Estado contra Vicente López.
Mr. Lopez, you're here because you've been accused of driving with no valid driver's license.
Señor López, usted está aquí acusado de manejar sin licencia de conducir válida.
You also have a hold from the United States Immigration Service.
También tiene una orden de retención de parte de Inmigración de los Estados Unidos.
I'm going to appoint the public defender's office to represent you and ask that you listen to your attorney.
Le voy a asignar la oficina del abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Lopez. He's going to plead no contest to the charges listed.
Su señoría, hablé con el señor López y él se va a declarar ante los cargos tal y cual se le acusa.
2 days in the county jail, credit for 2 days, $400 fine, which would be a civil judgment.
La condena serán 2 días en la cárcel con crédito por 2 días y una multa de $400 que sería un fallo civil.
He understands any plea can be used against him in the immigration court.
Él entiende que cualquier acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
Signed his plea waiver form, waiving his right to free trial and call witnesses.
Y él ha firmado el acuerdo y está renunciando a su derecho a un juicio y a llamar a testigos.
Understands that ICE will pick him up within 48 hours after this morning.
Él entiende que Inmigración lo recogerá dentro de 48 horas después de esta mañana.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Gracias. Y señor Mitchell, ¿está de acuerdo el Estado o lo está su señoría?
Mr. Lopez, did you hear that agreement?
Señor López, ¿escuchó usted ese acuerdo?
Sí.
Yes.
Do you have any questions about that agreement?
¿Tiene alguna pregunta acerca del acuerdo?
Sí, yo tengo una pregunta. Lo que pasa, yo tengo mi hijo, quedó aquí, apenas 2 años, porque nadie van a mantener, porque mi esposo no está trabajando.
Yes, I do have a question. I have a 2-year-old boy here, and who's going to support him? I mean, my wife is not working.
Mr. Lopez, if you enter this plea, your local charges are over with. You'll be released today on our charges.
Señor López, si usted acepta este acuerdo, sus cargos locales habrán terminado y hoy quedará en libertad por nuestros cargos.
But agents with the United States Customs and Immigration Agency have placed a detainer on you.
Pero los agentes de inmigración y borde de fronteras o control de fronteras le han puesto una orden de inmigración.
In other words, they believe there's a possibility you're in this country illegally.
En otras palabras, ellos creen que existe la posibilidad de que usted esté en el país ilegalmente.
And you'll be picked up within 48 hours of resolving our case.
Y lo recogerán en 48 horas después de resolver nuestro caso.
And whether or not they deport you, I have no idea. I can't answer that.
Y si lo van a deportar o no, no tengo ni idea. Eso no se lo puedo responder.
And the responsibility to take care of your child falls on you and the other parent, not on the taxpayers in the United States.
Y la responsabilidad de cuidar a su menor cae sobre usted y sobre el otro padre, no sobre los pagadores de impuestos de Estados Unidos.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No, solamente
No, that was it.
Is this the plea you would like to enter, sir?
¿Es este el acuerdo que desea aceptar, señor?
Sí.
Yes.
Mr. Lopez, I'm going to accept your plea of no contest to the charge of no valid driver's license.
Señor López, acepto su declaración de no me opongo ante el cargo de no tener licencia de conducir válida.
I'm going to withhold adjudication of guilt and sentence you to 2 days in the Jackson County Jail with credit for 2 days served.
Lo voy a condenar a 2 días en la cárcel del condado Bay con crédito por 2 días ya cumplidos.
I'm going to impose the mandatory fine of $400, and that'll be a civil judgment.
Le voy a imponer la multa obligatoria de $400, que será un fallo civil.
And Mr. Lopez, the immigration agency will be notified this morning to pick you up within 48 hours.
Y señor López, se le notificará a inmigración esta mañana para que lo recojan en un plazo de 48 horas.
If they don't pick you up within 48 hours as agreed, then you're entitled to be released.
Si ellos no lo recogen en un plazo de 48 horas, como es el acuerdo, entonces usted tiene libertad de quedar en derecho.
You will get to use the phone after first appearance to notify friends or family of what's happened this morning.
Le permitirán usar el teléfono después de las comparecencias iniciales y le podrá avisar a sus familiares y amigos lo que está pasando.
Do you have any questions?
¿Tiene alguna pregunta?
No, ya no hay nada, solamente este.
No, that was it.
Have a good day, sir.
Que tenga buen día, señor.
Next on our interpreter list, we have Victor Castillo.
El próximo en la lista de intérpretes es Víctor Castillo.
Mr. Castillo, good morning. You're here
Buenos
because
días, señor
you've been charged with driving
Castillo.
under the influence. You've been charged with one count of driving under the influence and one count of driving with no valid driver's
Judge,
license.
this is Robert Belorian.
I had them in the order on the interpreter list. Do you have Mr. Castillo there? Is there, you don't want to take them in that order for some reason?
Yeah, I was just letting him see the first one because I had a hard time communicating with him because he couldn't read and write. But I wanted to watch the first one. But this is Robert Belorian.
Okay, hold on just a second. I got to get to that packet in Mr.
I apologize.
Yeah, I got them. You're taking them in order on the list, which is normally how we do it. And since you called that other one, I thought you were taking them in the order they were on the interpreter list. So we've got a Beloin and we also have a Belorin. And this is Belorin?
Robert Belorian.
Okay.
Third one on
And
the
Miss,
list.
sir, good morning. You're here because you've been charged with one count of driving with no valid driver's license, and you also have a hold of the United States Immigration Service.
Buenos días, señor. Usted está aquí porque se le ha acusado de manejar sin licencia de conducir y también tiene una orden de retención de parte del Servicio de Inmigración.
There is probable cause in the complaint, and I'm appointing the public defender's officer to represent you.
Hay causa probable en la denuncia y le voy a asignar al abogado de oficio para que lo represente.
Please listen to Mr. McDaniel.
Por favor, escuche al señor McDaniel.
Your Honor, I spoke to Mr. Belorian. He's going to plea of no contest to the charges listed.
Su señoría, hablé con el señor Veloren. Él se va a declarar no me opongo ante los cargos, tal y cual se le acusa.
Understands he's going to be sentenced to 10 days in the county jail, 1 day jail credit, and a $400 fine, which will be a civil judgment.
Él entiende que se le va a condenar a 10 días en la cárcel del condado con crédito por 1 día y una multa de $400 que será un fallo civil.
Understands that any plea can be used against him in immigration court.
Él entiende que cualquier acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
Waive his right to a jury trial and call witnesses.
Ha renunciado a un juicio con un jurado y a llamar a testigos.
He understands that immigration services is going to pick him up within 48 hours of release from here at the jail.
Él entiende que Inmigración lo va a recoger en un plazo de 48 horas desde que quede en libertad desde el punto de vista de la cárcel.
And Mr. Mitchell's that agreeable with the state.
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está, su señoría.
Mr. Bloor, did you hear that agreement, sir?
Señor Veloren, ¿escuchó usted ese acuerdo?
Sí.
Yes.
Mr. Belorin, do you have any questions about that agreement?
Señor Veloren, ¿tiene alguna pregunta acerca de ese acuerdo?
No.
No.
And Mr. Belorin, is this the plea you would like to enter?
Y señor Valoren, ¿es este el acuerdo que desea aceptar?
Yes, sí.
Yes.
Mr. Blower, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Señor Valoren, acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
I'm going to judge you guilty of that offense and sentence you to 10 days in the Jackson County Jail.
Lo condeno culpable del delito y lo condeno a 10 días en la cárcel del condado Jackson.
You have credit for 1 day that you've already served, and I'm imposing the fine of $400.
Tiene crédito por un día que ya cumplió y le estoy imponiendo la multa de $400.
That court cost and fine will be reduced to a civil judgment if you don't get it worked off.
Esa multa se convertirá en un fallo civil en caso de que no lo trabaje.
When you get down to having only about 2 days left, the jail will go ahead and notify the Immigration Service to pick you up.
Cuando ya le queden como 2 días, la cárcel le notificará a inmigración para que venga a recogerlo.
And at that point, they will have 48 hours to pick you up.
Y en ese momento tendrán 48 horas para recogerlo.
Do you have any questions, sir?
¿Tiene alguna pregunta, señor?
No.
No.
Have a good day, sir.
Que tenga buen día, señor.
We
Victor
have
Castillo.
Gerard.
Victor.
He's not an interpreter, the one that's after him.
Oh, okay. Mr. Castillo, is that who you have, Mr. McDaniel?
Yes, Your Honor.
All right, Mr. Castillo, good morning. You're here because you've been charged with 1 count of driving under the influence and 1 count of no valid driver's license.
Señor Castillo, buenos días. Usted está aquí porque tiene un cargo de manejar bajo los efectos del alcohol y un cargo de manejar sin licencia de conducir.
You also have a charge of resisting an officer without violence.
También tiene un cargo de resistir a un agente del orden público sin violencia.
Mr. Jailer, that last charge has been left off of the jail list by accident.
It's on there. It's just right next to DUI.
Okay, it's on there. It's just, it's not listed
Yes, sir.
properly.
Yes, sir, we see.
So I'm going to appoint the public defender's officer to represent you, Mr. Castillo, and ask that you listen to Mr. McDaniel.
Señor Castillo, le voy a asignar al abogado de oficio para que lo represente y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I've spoken to Mr. Castillo. He's going to plead of no contest to the charges as listed.
Su señoría, he hablado con el señor Castillo. Él se va a declarar no me opongo ante los cargos tal y cual se le acusa.
Sentence will be 60 days in the county jail, 3 days jail credit, $1,078 in fines, which will be he'll work off while he's here in Trustee Bank.
La condena serán 60 días en la cárcel con crédito por 3 días y tendrá una multa de $1,078 que va a trabajar mientras esté aquí en la cárcel del condado con el programa de fideicomiso o de fideicomiso.
He understands that any plea can be used against him in immigration court.
Él entiende que cualquier acuerdo se puede usar en su contra en el Tribunal de Inmigración.
To waive his right to a jury trial and call witnesses.
Está renunciando a su derecho a un juicio con un jurado y a llamar a testigos.
Just a second, our deputy clerk has a pregunta.
Un momento que tenemos al alguacil que tiene una pregunta.
On the jail sentence, he'd be adjudicated guilty of both. Mr. McDaniel, anything else? Was that?
¿Es ese todo el acuerdo del señor McDaniel? Lo es su señoría y el Estado está de acuerdo.
I tried to fit it in there. It is agreeable with the state, Your Honor.
Y el Estado está de acuerdo.
Mr. Castillo, did you hear that agreement, sir?
Señor Castillo, ¿escuchó usted el acuerdo?
Sí.
Yes.
Sir, do you have any questions about that agreement?
Señor, ¿tiene alguna pregunta acerca del acuerdo?
Solo le diría de pagar fianza. Podría salir acá mismo, aquí mismo, pagar fianza.
If I were to post a bond, could I be released right here in case of a bond?
Estar aquí en este país.
And be here in this country?
Does he have a hold from the Immigration Service? Corporal?
They're waiting on one. I mean,
We're waiting on.
yeah, it's coming though.
Yes, he does have a detainer.
Oh, sorry. There is a detainer.
Okay, la
So the
pregunta
answer to the
fue,
question is no. I'm sorry, go ahead, Mr. Ricardo.
preguntaron, ¿tiene él una orden de retención de parte de inmigración? Y desde la cárcel confirmaron que sí, que tiene una orden de retención.
So in the last few minutes, the Immigration Service has placed a detainer on you, Mr. Castillo.
En los últimos minutos, el Servicio de Inmigración de Estados Unidos le ha dado una orden de retención, señor Castillo.
So that means if you post bond, will be held for them for 48 hours.
Eso significa que si paga la fianza o una fianza, se le mantendrá retenido para inmigración por 48 horas.
And if they don't pick you up within 48 hours, you would then be released.
Y si no lo recogen en un plazo de 48 horas, entonces lo dejarían en libertad.
But that has been very, very rare for the last couple of years.
Pero en el último par de años eso ha sido algo muy, pero muy raro.
The vast majority of people, they do pick up within 48 hours from our jail.
La mayoría de las personas la recogen, la gran mayoría la recogen de nuestra cárcel.
But you have the right to post the bond or try to post the bond if you wish.
Pero tiene derecho a pagar fianza o a intentar pagar fianza si lo desea.
So would you rather resolve the charges by the plea agreement or do you want to just post the bond?
Entonces, ¿desea aceptar a resolver el acuerdo aceptando el acuerdo o el caso aceptando el acuerdo o quiere pagar la fianza?
Hablaré para pagar fianza.
I'll call to pay bond.
Okay, we're going to give you a notice for your next court date then, and that will be June 2nd at 9 a.m.
Entonces le vamos a dar la fecha de su próxima audiencia, que será el 2 de junio.
9:30 a.m.
Disculpe, a las 9:30 a.m.
Do you have any questions?
¿Tiene alguna pregunta?
¿Cuándo sería?
When is it?
Your court date will be June 2nd at 9:30 in Jackson County.
Su audiencia va a ser el 2 de junio a las 9:30 en el condado Jackson.
Any other questions?
¿Alguna otra pregunta?
Nada más.
That's it.
Have a good day, sir.
Que tenga buen día.
I believe our last case or interpreter case is Ledwin Avila.
Your Honor, he's refused, unable to come out for first appearance. He's already got a
Okay.
bond set.
So he's got a bond set by the weekend judge. We'll just show that bond set at $5,500 on the DUI, $2,500 on the no valid driver's license set by, I believe, Embezzlement Judge Patterson this weekend. Mr. Ricardo, I think that's it, sir. We appreciate you.
Thank you, Your Honor. Have a good day.
You too. Just a second, Mr. McDaniel. All right, ladies and gentlemen at the jail, let me go back to the top of our list. Actually, we've got a couple people, at least one person that has friends or family here. Two people, that is. The first one's Thomas Brown.
Your Honor, he is not
Hey,
able to
come
come
on
out
up.
either. He's refused. I bet he's not doing very well.
Hey, come on up here, ma'am. So, Mr. McDaniel, we have Miss Brown from that home. So, ma'am, Mr. McDaniel, would you fill her in on he's just not able to understand what's going on or what?
He wasn't able to understand much of anything when we talked to him.
Right.
So he's been arrested and charged with one count of criminal mischief between $200 and $1,000 and one count of battery on law enforcement officers. He's got a felony and a misdemeanor charge. He's in jail. I'm going to set him a bond this morning. He's entitled to a bond. I'm unlikely to let him go back to that same placement facility, especially since he's been there 5 months and y'all still don't have his medication straightened out. I'm not saying whose fault it is. I have no idea whose fault it is. But I'm trying to protect the peace and the quiet of the community. And obviously that placement's not working for whatever reason. So I'm going to set him a bond and we'll set that bond and see what happens if y'all find a different placement facility or if you can get his medication under control. then we'll certainly consider other options. So
Yeah,
Miss-
'cause-
Go ahead, ma'am.
Yeah, because basically he got his blood work and everything, and so they should increase or do whatever the psychiatrist told me they was gonna do. They was just waiting on the blood work, and they do have that. So his medication should be regulated, and he should be borderline stable to be in the community. So we do
How many residents are in this particular placement?
6,
And how many staff members?
3.
Okay.
Yeah.
And Mr. Mitchell, anything from the state on the bond?
The only thing that I can make aware is that the officer does kind of allude that damages may be in the excess of $1,000. We'll have to kind of reach out and see if they've actually looked at it a little bit more. I just want to bring that to the court's attention, but other than that, we just, the standard usual conditions of release.
Mr. Brown, I'm sorry, I didn't even realize you were in the room out there. I didn't know they brought you in. Mr. Brown, do you understand what I'm saying, sir?
Yes.
Okay. Mr. Brown, I'm going to set your bond. Mr. McDaniel, you want to be heard on bond purposes, sir?
No, Your Honor.
Mr. Brown, I'm going to set your bond at $2,500 each on these 2 charges. Your total bond is $5,000. You have a condition that you can't go back to that residency right now. Now, if something changes that may justify that, but as a general rule, I'm not going to let him go back there unless there's a really good reason to. Usually we're going to try to find a different placement, especially when other residents are there that may have seen or witnessed or been involved with the altercation. So, Mr. Brown, I'm setting you a bond today. Ma'am, my suggestion is you contact Mr. McDaniel with the public defender's office and help get him some options.
Okay.
To get Mr. Brown somewhere else, and we'll try to make that happen possibly even today.
Yes, I can call
But
it.
he needs to be,
Yeah.
I don't know that he needs to be in jail, but he needs to be somewhere where he's secure and safe. And so is the public and other members of any house he's in. Go ahead.
I'm gonna call his psychiatrist because he's under the care of life management, and I'm pretty sure if we can, I don't know if you guys can transport him, I'll follow them there. Or if you, I don't know if, you know, the stipulations, but I'm gonna post bond, and I don't know if they can transport him to life management because he is under their care. And with the incident that just transpired, I'm pretty sure, and the blood work in, I'm pretty sure that he can actually get his medication regulated.
Are you going to post bond with his resources?
No, the group home.
Okay, I don't know that posting bond may not be necessary.
Okay.
If we have a placement location
Yes,
for him.
yes.
So the sequence would be get him a placement location, and then it
Okay.
can save you the bond money.
Okay, okay.
But if I have somewhere for him to go, I
Yes.
would consider some other type of release without having to post a bond.
Okay.
But I can't do that until I know he's got somewhere to go and I know where that is.
Okay, I could
Okay.
get on that as soon as I leave here.
So, Mr. McDaniel, do you want her given your office number? Do you want her given a different number? So if you don't, can you write down the publisher's office number, please? And we'll give it to her. If you don't know it, hand me the pad and I'll write it down. So, ma'am, this is Mr. McDaniel, his attorney for today's purposes,
Okay.
his office number.
Mhm.
And let him know what you find out when you talk to the psychiatrist or
Yes.
whoever else about other placement options. 9366. And she's writing a name on here of Sissy.
Okay.
Sissy is Mr. McDaniel's assistant.
Okay.
So that's who you probably need to talk to.
Okay,
Okay? That's the
you.
phone number. Thank you, ma'am, for coming today.
thank you.
All right, Mr. Brown, we'll see you in the future, in the near future. Have a good day, sir.
He does need his court date, though.
I'm sorry, say that again.
He does need his court date. But I think
I don't know if he's capable of understanding the court date.
He can't understand.
Corporal, if he is released, we need to give the court date to whoever picks him up. Corporal,
Yes, no
and
problem.
that would be June 2nd.
Yes, sir.
Is it June 2nd, 8:30? Thank you, Corporal. Thank you, Mayor. And we have friends or family here, Mr. McDaniel, on Louis Pomona. Last one we have somebody here for. Mr. Carmona, good morning. Your ex-wife is in the courtroom. Mr. Carmona, you've been accused of 2 counts of violation of an injunction and 1 count of installing a tracking device without consent. That third case is a felony charge. The first 2 are misdemeanor charges. Mr. Carmona, I've read the complaint. There is probable cause for the 3 charges. I'm appointing the public defender's office to represent you for first appearance purposes. Please listen to Mr. McDaniel, your attorney.
We just asked for reasonable bond.
Mr. Mitchell.
Your Honor, there are safety concerns when it comes to the victim. In this case, it's the same victim on all 3. we'll leave the amount of bond up to the court's discretion, but we just want to emphasize that he had absolutely no contact whatsoever with the victim in this case.
So Mr. Cremona, thank you both. Mr. Cremona, I've looked at your history. I see a couple things, but they're old, and I mean over 30, maybe even 40 years old, close to 40 years old. So your criminal history is not that concerning. The charges are concerning. The allegation is you're ignoring a judge's order, but I think you're entitled to a bond. I'm going to set you the normal bond I would set for someone with these charges, which is $2,500 each on the misdemeanors, $5,000 on the felony. Your total bond today becomes $10,000 cash or surety. Mr. Cremona, you have a condition of no contact with the alleged victim. That means in any manner. Let me try to clarify. Sometimes with an injunction, the person who has the injunction may contact the you, for instance, and say, I want to try to talk to you. If he or she does that, I think it's a she, if she does that, you still can't talk to her. So you've got two court orders now by two different judges, and you need to understand, here's the difference. If you're accused of violating this court order, no contact, the one I'm giving you today, and if there's evidence to support it, then I would revoke your bond and hold you with no bond. So it's you kind of get one shot. You're entitled to a bond on violation of injunctions, and I'm setting you a bond. But if you allegedly violate that, and there's credible evidence to support it, this current one supposedly was supported by electronic messages or emails or phone messages. So that's the evidence, not just somebody saying you violated. It would take a little more than that. But if that's there, Mr. Cremona, you could be in jail with no bond. So please take it very seriously. The no contact condition does apply. You've got a condition of a court date on, well, actually it'd be two court dates.
I think it's June 1st.
You've got some cases in misdemeanor court and some in felony court. June 1st will be which ones?
The misdemeanors.
June 1st, the court date will be at 9 o'clock. June 2nd at 8:30. That'd be the felony date. They'll give you that notice before you leave the jail. You will get to use the phone before you leave to try to postpone. Let me see if your ex-wife has any questions first. Ma'am, do you have any questions? Mr. Cremona, do you have any questions? No. All right, sir. You'll get to use the phone in a few minutes, sir. Wish you the best.
Okay, Gerard.
You good? Good. We have Gerard Beloin. Sir, good morning. You're here because you've been accused of one count of armed trespass with a firearm and one count of possession of firearm by a convicted felon. There is probable cause for the charges. I think you're entitled to a bond as far as I can tell, but I want to listen to the parties before I make that final decision. Mr. McDaniel, anything on behalf of Mr. Beloin?
No, I'd like to speak myself, please. I don't have.
Okay, I'll give you a chance to ask questions or say anything in just a moment. Mr. McDaniel, anything first?
I don't have anything, Your Honor, except some, he'll probably, hang on, just don't say anything.
Okay. Mr. Mitchell.
Not at this moment. I do want to see what he says.
Mr. Beloin, I would encourage you, don't talk about what you're charged with. I'm glad to hear anything you think is important for bond purposes, but we are being recorded, so don't talk about the actual case itself because it could be used against you. Anything you want to tell me for bond purposes or any questions you have?
All right, advise Mr. Gerard that not to talk, that he wants to talk, and just my communication with you, there might be some issues going on, but I'll let him.
There's no issues going on. It's a big mistake, Your Honor. I was staying at the Love's travel stop.
Advise you,
I stayed there for a week or so, and I was asked to leave, and I left, and I came back to the McDonald's parking lot, and I was in the McDonald's parking lot. I assumed there was different.
You have a question, he's asking if you have a question.
Oh, I didn't hear you.
Yeah, do you have any questions? I mean, you can tell me anything you think is important for bond purposes, but you basically admitted to a crime almost in that sentence you just said. Do you have anything else you want to tell me, sir? Any questions?
I'm just telling you that there was no signs. I went to the McDonald's parking lot, not the Love's parking lot. So I was confused. It was a mistake. And if I do it again, I wouldn't do it. But I assumed that the McDonald's parking lot was not the Love's property. So and the firearm charges, they're bogus.
Okay. All right. The most serious charge you have is the firearm charge. I'm going to set you a bond of $5,000 on the trespass with a firearm and $15,000 on the possession of firearm by a convicted felon based upon your criminal history that the officer included in the complaint. Your total bond today, sir, is $20,000 cash or surety. You have a condition of no contact with any Love's truck stop. And just to be clear, if a Love's truck stop is in the parking lot and they have a McDonald's attached to that building, don't go in that parking lot at all, period. That's how I would interpret if I were you. No contact with any Love's truck stop while this case is pending. I'm going to give you a court date. Your court date will be June 2nd at 8:30, and you will use the phone in a few minutes, sir, to try to post the bond. Do you have any questions?
Nope.
Have a good day, sir.
Chad Chambers.
Truck stop was LUV or LOVE?
I think that's LOVE.
All right. Next is Mr. Chambers. Mr. Chambers, good morning. You're here. You were first appeared this weekend, and what I've been explained, because I had to call the jail to find out for sure, it looks like that you have a hold out of Columbia County. You were not first appeared on this weekend. They weren't aware of it or didn't make you aware of it for whatever reason, and they wanted you to be aware of that. I've got a copy of the teletype, which is basically an email from that agency that says that you have a violation of probation, no bond warrant out of Columbia County. So be aware, you've got the bond set for you by the weekend judge. If you post it, you'll be released, but you will not be released to the street or into the public. You'll be released to Columbia County's custody because they do have this active warrant for you. Mr. Chambers, any questions?
I'm trying to figure out the right way to word it, sir. So you're saying that if I posted bond, I would still be held until Columbia County comes to pick me up, correct?
Yep. Here's what will happen. If you post bond, Columbia County will be notified immediately. He's posted bond on his local charges. Y'all can pick him up. And then Columbia County will pick you up. If you're still here in 15 days after that point, then you would come back to first appearance. I'd say, Mr. Jailer, where do we stand on the transport? What have you heard from Columbia County? And they will tell me, and we'd go from there. There's a good chance, though, that they would pick you up within 15 days and I wouldn't see you again. But that 15 days is just kind of a safety catch we put in place to make sure somebody doesn't sit here for weeks. So, yes, you would be held until they picked you up or until 15 days pass, whichever happens first. You might not be released on 15 days if they were coming the next day, but at least we would know what they were telling us. Any other questions?
So if I didn't post bond, I still have to sit here on these charges?
Right. If you don't post bond, you deal with our charges first and then deal with Columbia County. If you post bond, you deal with Columbia County's charges first and then ours later.
Same questions I've already answered. Is you have something else?
I'm not understanding how
You
this
do
is.
understand it.
I can't make it any clearer than that, sir. I don't know how to make it any clearer than what I just did. That's as clear as humanly possible. I believe we have
Patricia Butler.
Oh, you got the add on.
Patricia Butler. Miss Butler, good morning. Miss Butler, you were added on because, let me see, I wrote it down. You were held, I guess, for 7 days to see if there was a violation of probation warrant. There has been a violation of probation warrant. I saw it this morning, signed by Judge Roberts, and it does have no bond. So, Ms. Butler, you do have a no bond warrant, and I think it was Holmes County. Is that correct?
Yes, sir.
You got a no bond warrant out of Holmes County, Ms. Butler, and I'm not sure the jail didn't put that. You're not on the sheets. I don't know if you have local charges or not. Does you have local charges, Corporal?
Yes.
So you got your bond on your local charges. If you have a bond and you've got a hold out of Holmes County, any questions?
Is there any way we can globalize the two?
It's rare, but it's possible. It would have to happen with your attorney working to do that prior to resolving your Jackson County charges. So once you get an attorney appointed and meet with that attorney, that's the question to ask that attorney, ma'am.
Okay, thank you.
Yes, ma'am.
Oh, we got you.
Daniel, is that it?
That's all.
Thank you. And Corporal, anything else from the jail this morning?
Anything else?
All right, it would seem that they have wrapped up there. Good morning once again, everybody. Now in hour 2 of TCF Live. The mornings just zip right along when you're here. Let's go back to Huron County and Judge Prill. Now, if you recall earlier this morning that Mr. Kaufman was supposed to be sentenced. He was the funeral home director who defrauded like 200 people of the community or something like that out of over $1 million. And he did not show up for his sentencing. So this is part 2 of that. Let's see what's going on.
Alvin Kaufman, file number 26, 7390 FH, time and date set for the defendant's sentencing. Mr. Kaufman is in the courtroom represented by Attorney Elizabeth B. Weisenbach. On behalf of the Attorney General's office is Attorney Michael Trescone. The defendant, by way of history, on March 16th of this year, pled no contest to 1 count of criminal enterprise, 2 counts of embezzlement, $20,000 to $50,000, 5 counts of embezzlement, $1,000 to $20,000, and funeral contract conversion, 31 counts. A pre-sentence report has been prepared by Ms. Karen Everland, dated April 21, 2026. A number of letters have been submitted to the court. Those letters have been provided by Susan Mergel, MERGL, Judy and Thomas Crager, CREGUR, Dan and Betty Jo Glaza, Cynthia Phillips, Larry Brown, Marilyn Gilbert, Emily Ginther on behalf of Norman and Shirley Ginther, Lena or Lena, Lena Soper, the Public Guardian's Office, Jacqueline Braun, Kenneth Clement, Betty Lou Burkhardt, Mary L. Gilbert, Gary and Wendy Ayotte, Ayotte, Ted and Carol Polk, Cynthia Rutkowski, Wayne and Lila Mae Clemmer, Raymond Gentner, I believe it's Luke Martin, I couldn't read the signature, as well as Helen, Donna, and Dennis Storkel. There were other letters that were kind of chopped off a little bit. The court could not get the names, but the court did review all the letters that at least placed on the record the court has submitted. Ms. Weisenbach, have you and your client had the opportunity to review the pre-sentence report?
We have, Your Honor.
Are there any additions, deletions, corrections, or objections?
Thank you, Your Honor. In my meeting with my client, we had discussed the phone number that was listed on this, and I was in contact with Michigan Department of Corrections. That is his wife's phone number. He did not have a phone after this had started, so I asked for that number to be stricken. It is her number. It is not his. It should not continue in this record, and I appreciate they have updated and we have received that.
All right, anything else?
Yes, also I direct the court to page 6. There are 5 paragraphs that conclude the section entitled Description of Offense Narrative. That begins on page 3. On page 6, there are 3 paragraphs. The 2nd paragraph, the 4th paragraph, and the 5th paragraph are all ancillary information, not part of this investigation, unsubstantiated. Basically started off with gossip and rumors. They chased that around, and I think it's inappropriate to include that. It's not part of these charges. It is not part of this true investigation. And as a result, I asked the court to strike it. Your Honor, you do strike things that are not charged, cases that are dismissed, factual information. We just did it a couple of weeks ago. I would ask you to strike these 3 paragraphs and to not have any consideration towards there is sufficient information for this record in order to consider your sentencing today. I would ask you to strike those 3 paragraphs. They just shouldn't be part of this record.
Mr. Tresco, your response, sir.
Your Honor, this case was charged. As a result of this case, numerous other victims came forward and we continued investigating essentially where all the money had gone. So I understand Ms. Weisenbach's argument in that Mr. Kaufman is being sentenced today for stealing $192,000, although much, much more was stolen. The information contained in those reports and contained in the ongoing investigation is germane to what became of that money. And we believe, regardless of the amount that Mr. Kaufman spent on lottery tickets, whether it be $192,000 or $1.1 million, I believe it's important for the court to know essentially what his scheme was funding, which was his addiction to lottery tickets.
Ms. Weisenbach, final comments.
It's inappropriate. It doesn't belong in the PSI. We do not ever chase where the money went. We do not chase that when we consider larceny cases. We do not consider it in other types of cases. So restitution, et cetera. Restitution has been handled and agreed upon. Victims have been listed and agreed upon. It's irrelevant, and I think it's inappropriate before this court.
Any comments from the probation office?
Your Honor, that information was obtained from his report, and that was why it was included in the PSI.
All right, thank you. Well, the court has heard the respective objections by Ms. Weisenbach on behalf of the client and the response by the people, as well as hearing the comments from the probation agent. Frankly speaking, there's no doubt that restitution has been agreed to, the amounts that is, but relative to where the money was or where it went, I think is important to understanding what efforts the court would have in getting the money back. So I think it's very relevant. Objection is respectfully denied, Ms. Weisenbach.
Thank you,
Anything
Your Honor.
else for the record?
Not with regards to PSI.
Okay. And guidelines are finalized, correct?
Yes.
Mr. Tresco, any objection to the report as well as guidelines?
Your Honor, I believe based on Mr. Kaufman's behavior this morning, that OB 19 should now be scored at 10 points. The OB 19 is not offense specific. Any behavior occurring up to sentencing can be scored under OB 19. And I believe that failing to appear for a sentencing hearing counts as 10 points for otherwise interfering with the administration of justice.
Ms. Weisenbach.
Thank you, Your Honor. This morning at approximately 8:18 a.m., just a little under an hour before we were to proceed with court, I received a phone call from Mrs. Kaufman that her husband had an injury and she was taking him to the ER. We had a brief conversation with regards to that. I asked her to keep me posted of his whereabouts. And I have paperwork in front of me that he was at McLaren Regional Hospital. I'm letting the court know, and I can present this to Your Honor, that he had suffered a concussion. I have this in front of me. He now is sitting in front of you with a concussion, having suffered this morning. There was no, as far as I can tell, except for comments made by the Attorney General that are out of the record for anything else except just today. There is no information that I have that my client has attempted to not be in court. He has been at every court hearing. He has been at every meeting that I have asked him for. He has met with the investigators. He gave statements. They are in the PSI. And to say today that he was dodging today, his wife called me and said, this is what happened, what to do. And I told her to take him to the hospital. That is where he was. I have yet to give any disparaging comments to this court to mislead this court or anything to that effect. And my client has told, his wife has told me where he is. We've known where he is. He went from home to a hospital and now he's here. I would ask the court to disregard any request made today with regards to PSI, I'm sorry, with regards to sentencing guidelines. And they were due a week ago or more. So I understand the position is that somehow it's an emergency to them today. It's not. He was in the hospital and I can approach with this documentation.
Your Honor, regardless of whether the reason he was at the hospital, the fact is the court signed a warrant. My special agent went to the hospital to try to arrest Mr. Kaufman. Mr. Kaufman had already been discharged and had gone home. Had Mr. Kaufman been discharged and come to this court, I might not be making this argument, but the fact is he chose to go home and he was arrested at home and brought here in handcuffs.
All right.
And with regard to the time frame, I don't know how I could have possibly made this argument a week ago since that it happened 2 hours ago.
Also at 9:35, his wife stated that he was discharged. She sent me a screenshot of the paperwork and I texted her back that you have to bring him to court. Judge had issued a bench warrant. So all of this was going on at the same time. I had told her to bring him here, but moments later, then she said, okay, 10 minutes later at 9:55, she said that the sheriff and a prosecutor came and picked him up and they're leaving. So no one's been dodging anything or avoiding anything. His wife had been in contact with me. He was having a concussion. He wasn't in a position to make any specific actions with regards to his behaviors today. She took him to the hospital. She was going to bring him here. They just got there first. That's the only difference. She has been very compliant, very appropriate this whole time. There's nothing to be held against her.
Well, she's not the one before the court, her husband.
Understood, but I want you to be aware of who I was communicating with this morning. My client was in no position to communicate with me.
Sentencing guidelines can be considered up until the time of sentencing. Obviously, if there's an objection relative to what probation department had scored, then certainly that's why the timeline is there. But certainly circumstances can arise where, for instance, OV-19 may be in play that the court would consider. But based upon all the circumstances, the court is going to continue with sentencing with the original guidelines for OV-19 respectfully is denied relative to 10 points. Any other objections to the reporter guidelines?
No, Your Honor.
Ms. Weisenbach, is there anything you'd like to say on behalf of your client before the court imposes sentence?
I believe that at this point, I am required to ask this court to consider an adjournment in light of the fact that my client is sitting here with a concussion that is medically documented. I can approach the court with this documentation.
Show it to Mr. Tresville first. That's going to give the opportunity to review the document.
I have, Your Honor.
Your position, sir.
Your Honor, I don't see what the point of an adjournment is at this point. Mr. Kaufman has admitted his crimes. He's here to be sentenced today. He'll get excellent medical care in the Department of Corrections.
I would like to present the materials.
Thank you, Your Honor.
Is this the discharge documentation?
That's my understanding, yes. That's what he was sent home with.
There's no indication alleged fall occurred. Nothing.
That's what I had received.
Is there anything in the medical documentation to indicate that the defendant is unable to understand what's going on? The head injury, alleged head injury is traumatic enough where he wouldn't appreciate what's going on today?
That's inherent in having a concussion. That's what the concussion is.
Your Honor, I strongly disagree. And I believe that Mr. Kaufman, Ms. Weisenbach can voir dire her client if that is in fact the case, but I would ask the court to also take testimony of the client that he does not understand what's going on today before the court considers an adjournment.
Raise your right hand, sir.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes. Ms. Weisenbach.
Can you hear well enough?
Yeah.
Okay. All right. Jerry called me this morning, right? Your wife?
Yes,
And you were aware that she called me?
yes,
Okay. You supposedly had a fall this morning and then she was taking you to the hospital, correct?
yes,
Where did you go to the hospital?
here in Bad Egg.
And what's the name of this hospital? Okay. How long were you there? Do you recall who you had seen as medical treatment people?
I don't know their names.
Just kind of give me like a, what happened at the hospital?
They hooked me up to things and then they did a CT scan.
Okay. Describe what happens during a CT scan.
You lay on your back and they put you into a tube. And I'm assuming the camera goes over you.
Okay. Was it just your head then?
Yes.
So you had a head injury?
Well, he said I have a hematoma in the back of my head.
Okay. Are you able to hear and understand everything that's happened today?
Yes.
Do you feel that the injury to your head has caused you any issues with regards to understanding the judge?
No.
Okay. I have nothing further, Your Honor.
Any questions?
Don't see any basis to grant an adjournment.
Based upon the sworn testimony, the defendant understands what is proceeding, or what the proceeding is all about. On his own sworn testimony, we will see the sentencing right now. Weisbach, I'll tender that back to you.
Thank you.
I'll hand you this. Well, is there anything you'd like to say on behalf of your client before the court will close the sentence?
Thank you, Your Honor. Yes. I met with my client last week to review the PSI. Also available were the victim letters. I want this court and I want everyone to understand I read every single letter. I read every single letter, every heartfelt thought, everything that was in there. I understand their position. With all due respect to the victims, my comments are never meant to be disrespectful. But there are two sides, and today is the side of Terry Kaufman. He comes before this court, 72 years old, actually no criminal record, married, 3 children, high school diploma, advanced education, and just about 50 years of providing compassionate funeral service for many, many grieving families over many years. Kind, considerate, soft-spoken, polite, respectful, and for yes, many years, well-respected citizen businessman. In these letters, I know you've read them too. There are stories of kindness, seeing that he had gone above and beyond what was necessary in his advanced years, shoveling out a driveway just so that a funeral could take place. As he had stated in his comments during the investigation, this money was not sent into the escrow. It was used to put back into the business, especially payroll. There were other people on the payroll, other employees. Yes, he was an employee. There were slow times. There were lean years, and the doors could have closed. The doors were kept open because of that cycle of money coming in. It's not a secret that funeral business has been changing. They are struggling. There has been, in my area where I live, a murder, Elkton, Caseville, Pigeon, Cass City. And I tried to look it up this morning, but I think that Seaboyne has had to merge as well. Coffins would have closed many years ago if it hadn't been for this particular income, provided this service all these years for these families. During this time, he was not living extravagantly. There's a lot of people who know him, who know how he lived. There are a lot of people who don't. There are, have been made comments outside of this court with regards to living an extravagant life. He lives in a modest ranch house, and the court has seen in the PSI there's still a mortgage. And in return for living modestly and keeping a business open, those who had passed were given their funerals. It didn't matter if it was at that funeral home or if it was at a different one. The money went to wherever the funeral was held. And this actually happened in the case that triggered this situation. The money was always sent and it was covered. Credit was given, and he honored the word to the people who he had told them that it would be okay. And he always expected and planned on honoring that. I could not ask for a better client when it came to appropriateness towards me. He has been polite, respectful, kind, generous, and compassionate. He understood my position. He understood the role I served. He was always appropriate, always on time, always came to the meetings I asked for. As you can read in the PSI, he is resigned and accepting of what is going to happen. He is aware, and he is fully prepared to accept the sentence from your honor. With that being said, again, I'd like to remind everyone there's two sides. There was a business that kept going for the people of this community. It was not exactly the way it was supposed to be. I get that. So does he. There's just always two sides. And I appreciate your honor and everyone's understanding of that. Thank you.
Does your client wish to address the court in light of the no contest?
Also, in light of the lawsuit that has been filed, no.
Very well.
Thank you, Your Honor.
Mr. Tresco, anything on behalf of the people, and this is a victim's rights case.
Yes, Your Honor. Before I make my argument, I would like Ms. Vaughn to address the court on behalf of her wards, the 55 victims named.
State your name for the record. She can stay right there.
My name is Jacqueline Braun. I'm the Huron County Public Guardian.
You may proceed. What would you like to tell the court?
Your Honor, I represent 55 people who have been taken advantage of by Mr. Kaufman. These people are either illegally incapacitated or developmentally disabled without the ability to care for themselves. Some of them do not have the ability to understand what has happened to them. These people do not have much. The little they do have is carefully budgeted and spent so that they may live comfortably, and so they are cared for. The money in the prepaid burials was mostly supplemented by the stipends sent out during COVID. That money was carefully done. That money will never be replaced. Some of these individuals will never have anything extra to pay for a burial or put into another prepaid again. That is why the careful planning was done. That is all for nothing now. All of that planning is gone. I ask you to take into consideration the impact that will have on these people that do not have the ability to care for themselves or understand what happened here, as well as take into consideration what has happened to the rest of the victims in this case. Thank you.
Thank you. That's good. Any other?
No other witnesses, Your Honor, this argument.
You may proceed.
Your Honor, Mr. Kaufman argues for leniency based on his lack of criminal activity. Mr. Kaufman admitted to 39 felonies, including criminal enterprise with predicates spanning the last 10 years. So it's not for lack of trying that Mr. Kaufman has no criminal record. It's simply that it took a while for him to get caught. He argues for leniency based on being a respected member of the community, but the fact is he abused that respect in his position in this community to steal from the members of this community. He claims he did this to keep the business afloat, but his bank account records showed that he paid himself $1.5 million in the last 10 years. That wasn't money kept in the business. That was money that was moved to his accounts, including secret bank accounts his wife didn't know about.
Your Honor, I'm going to object. None of this is in the record. And I would also like to point out that as of yet, my client has not asked for any leniency, but in fact was ready to plead 3 or 4 proceedings back, but the Attorney General's office wasn't prepared. My client wants this record to be clear. He never wanted to ever come before this court and say not guilty. He never wanted a trial, and he hasn't asked for leniency. I would ask that the pre-prepared speech that's maybe cookie cut for every other case be tailored to exactly what's going on today. My client did not ask for leniency. My client isn't dodging coming to court. And anything extraneous that's not inside this record, I think is inappropriate with regards to it being argument, PSI, whatever. Thank you.
Noted for the record. May proceed.
Thank you, Your Honor. He also claims that, again, if someone came to him for a funeral, even though the money wasn't escrowed, even though the money was gone, he still did the funeral. And of course he did, because the minute he misses a funeral, the jig is up and he's caught. And that's what happened. Somebody else went to have a funeral at a different funeral home, and that funeral home found out the money was gone. And that's how this all came to light. Your Honor, the sentencing guidelines do not address the level of criminality that Mr. Kaufman engaged in. He scored 25 points on OB9 for having 20 victims. He had 55 victims. He scored 5 points on OB13 for 3 or more property crimes. He admitted to 38 property crimes. And he scored 10 points on OB16 for a loss of $20,000 or more. The loss was over $192,000. Based on all that, the people are asking the court to, at a minimum, sentence Mr. Kaufman to the top of his guidelines, with count 1 running consecutively to counts 2 through 8 for a total sentence of 108 months or 9 years. Thank you.
You're welcome. These are not easy cases. court notes the number of individuals in the courtroom, I respect each and every one of you for being here. I respect any support that Mr. Kaufman may have received from family or friends as well here in the courtroom, because the court has to be right down the middle. And the court is going to be right down the middle, because at the end of the day, what may be investigated may be different than maybe what have been pled to, but regardless, we have a significant amount of activity that affected a lot of people. And a lot of people. A lot of people that put their faith and trust in this individual. And I couldn't imagine, considering my parents or anyone's parents or anyone planning for their future, because we all know when the good Lord says that's the day, that's the day. And the last thing we want to do is ask our children or our other family members or friends to get through that. And that's why a lot of these individuals that appear before the court as victims planned for that. And they scrimped and scraped and used whatever they had to make sure that it made it easier for the family upon the death of the individual. And so just looking at some of these letters, for instance, I trusted him, so I wrote a check for $6,691. I'm angry that my prepaid funeral has been stolen. My children are upset that my funeral is now their responsibility. We gave him $15,990. He gave us papers showing that we have paid for both funerals, and we were all set. Both of us are in our 70s and 80s. We have difficulty with degenerative arthritis, walking and memory. Dealing with these issues only makes the stress worse. We trusted Mr. Kaufman as an upstanding member of the community. He assured me that with the funds that I was giving him at the time of my death, the funeral home would arrange everything. All my children would have to do was grieve. I do not understand how a man trusted by his community could so recklessly steal from us. Terry Kaufman took my hard-earned and saved money to use for himself. Due to what Terry Kaufman has done, I feel hurt, angry, betrayed, and humiliated by my trust. I had a pre-need contract taken out in 2016 for $10,000 that was totally gone. I've lost countless hours of sleep worrying about the victims and how they would get justice. That's from a former employee. Despicable that someone who's a funeral director would take money from elderly sick people and use it for his personal gain. When a loved one dies, it's a very pathetic event. My contract is outstanding and the money is missing. We trusted that $15,000 would be handled with care, honestly, and with respect. Situation has affected us not only financially, but emotionally. From a 94-year-old individual. I considered making prepaid funeral arrangements for myself at the time I had the finances and wanted to spare my family from having to endure the burden of experiencing the difficult process. I can still remember a few days later, he delivered the contract to me with a cover letter, and on the envelope he wrote, "You're all set." I felt so many emotions: disbelief, betrayal, anger, and sadness. How could he do such a despicable thing to me and many other people? Now I must face the fact that my prepaid funeral expenses are gone. I will need to start over. The situation has caused our family many sleepless nights and anxiety about how we will bury our father. I had prepaid $10,000 and had the money in the trust of Terry Kaufman that it would be taken care of until my death. Now I have to sit and worry and wonder how are they going to bury me? I don't know if I will ever be able to trust anybody again. I've just been sick over this. I thought I'd be saving my family from having to deal with my funeral expenses. I can enjoy my retirement with peace of mind. I had put trust in him. My stress level has been affecting me every day, my everyday life from this. I've been worried and wondering how my funeral will be taken care of now as the money is gone. We are in our late 70s on a fixed income. Mr. Kaufman assured us that all would be handled properly and professionally. We've never met anyone of this nature before and have no reason to doubt his word. Hurt and disappointed. Beside our payment, we put our trust in him to provide our funerals with a proper end of life, burial, and with dignity. What he really took cannot be replaced, and that was our trust. We should have been able to have our confidence in his relationship with us and in his services. If not him, a professional and a neighbor who shook our hands and welcomed us with open arms, who can we trust? We truly trusted him to provide us with our final farewell. I believed I was dealing with a trustworthy and professional business. I relied on their representations and trusted my money with the expectation that it would properly be safeguarded and used for its intended purpose. I have experienced ongoing emotional distress, worry, and uncertainty. It is extremely upsetting to realize that the plans I made in good faith may no longer be secure. This is not a small amount for me, and my replacing these funds would be difficult. What has been most difficult is the loss of trust. My husband and I have known Terry for years as we have sat across from him at his desk. We respected Terry and looked forward to his help and guidance on my mother's eventual funeral, as well as mine and my husband's and family. We regarded him as a friend, someone to trust, someone to call on in time of need. Always a smile and a handshake or a hug for both. Needless to say, my heart sank and my mind was a jumble, wondering if and how we could get our $21,000 back. Our funerals to ease our burden on family when the time comes, that is, for our funeral. There's no excuses as far as we are concerned. What would happen if the roles were reversed and we had taken his money to gamble it away? We would be held accountable. And the notes continue in that stream. Mr. Kaufman, you were trusted. These people in this room, everyone that's contracted for services that have been affected by this case, put their faith and trust in you. And what happened with the money, it's alleged. I don't know what happened to the money, but when you're talking about restitution of 1.1 million, that's clearly beyond the pale. And that's clearly an issue of trust that will affect these people for the rest of their lives. Simply going into a store, simply going in to hire someone for lawn service, whatever it may be, any meaningful or meaningless task, frankly, these people are going to question that every time. Am I getting scammed? That's what they're thinking. And frankly speaking, there is no jail or prison sentence that's going to give everyone their money back right now. If the court could do that, the court would do it in a heartbeat, but the court's unable to do so based upon the behavior of the defendant in this case. And as a result of that, the court has to consider the guideline range, which is 51 to 85 months at the minimum term. To the defendant's credit, if there's credit to be provided, up until the time the gig was up, individuals were provided their funeral services. That's not the way to run a railroad. Not the way to run a business. We understand that people have difficult times and difficult issues, but when that money is entrusted to people, to a person that it's their end of life decision, that's one of the most important decisions we have to make in our adult lives. And these poor people lost that. And now they have to start over again. Considering the guideline range in this matter, considering the number of charges, convictions that is, 31 just for the funeral contracts, 5 for embezzlement, $1,000 to $20,000, 2 for embezzlement, $20,000 to $50,000, and clearly the criminal enterprise. One could argue that the guideline range may not be sufficient. However, on the flip side, the upper courts, the Court of Appeals, Michigan Supreme Court also looks at the guideline range, which is only considered, the court is to consider the recommendations. But the sentence has to comport with the law, it has to comport with other factors, facts and circumstances, considering the guidelines, and it will be the sentence of this court that first, in count 1, well, actually, let's begin with the embezzlement $1,000, no, back up. Counts 4 through 39. This includes embezzlement, agent trustee, $1,000 or more, but less than $20,000, $5,000, 5 counts of that. And the 31 counts of conversion will be the sentence of this court. And the guideline range is lower for this, but defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of 23 months to maximum of 10 years with credit for 1 day served. Actually, that also covers, back up. I apologize. This pre-sentence report is rather lengthy. The sentence will be 23 months to 5 years with credit for 1 day served. That's the guideline range relative to counts 4 through 39. That's the maximum guideline the court can impose. Counts 2 and 3, embezzlement, agent or trustee, $20,000 to $250,000. It will be the sentence of the court that the defendant be committed to the Michigan Corrections Commission and placed in their custody for a period of 23 months to 10 years with credit for 1 day served. Finally, regarding count 1, criminal enterprise, will be the sentence of this court that the defendant pay restitution in the amount of $1,111,165.77. He's to execute a wage assignment and to pay with that restitution if he's employed and misses 2 regularly scheduled payments. Crime victims assessment of $130 will be ordered. DNA testing fee of $60 will be ordered. State costs total $2,652. Those court costs are due and payable by July 6, 2026, or the 20% interest penalty is imposed. Finally, based upon the number of charges, the number of victims in this case, the amount of money involved, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission and placed in their custody for a period of 7 years, 1 month to 20 years, credit for 1 day served, which is again the maximum under the guideline range. The court imposes the maximum based upon what the court already stated. The victims, the amount of money involved, the number of victims, I should state, the money involved as well. It will not provide solace to anyone in this courtroom. It won't provide solace to the defendant. It's not going to provide any relief for anyone. But the court has to impose all its conditions based upon the law. The hope is that the restitution can be recovered and the court will stay diligent in efforts to collect that restitution. But based upon his sentence, it's going to take a large amount of time. I do have to inform the defendant he has right to seek leave to appeal. If he's financially able to provide counsel of his own choice, court will assign counsel for him at public expense. He's to initial receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. These sentences shall be served concurrently with each other. There was a request for consecutive sentencing. However, based upon the defendant's age and based upon the fact that if there's more time imposed, that gives a lesser opportunity for the defendant to provide funds for the victims in this case. The court is going with a concurrent sentence. Has he executed the document?
Not yet. I think he was listening. He wanted to hear the end of it.
That's fine. That's fine.
A lot of other people just start firing.
That is remanded to custody of the sheriff. All the individuals that were here monitoring this, if you wish, feel free to go. If around, they do so as well. Authorized.
Okay, friends, so it sounds like 7 to 20 as I heard it, Barbara. So a minimum of 7. If I recall, he's 71 or 72 years old, based upon the average lifespan of male in the United States. That's a life sentence, more than likely. Is that justice? I don't know, because they'll never recover this stuff. At least not to the tune of 1.1 million. You know that. I mean, they could try to liquidate what he's got, but there's going to be some difficulty with that, especially if the wife's name is on it too. Could be a mess, so we shall see. I'm fairly certain this is going to be our sidebar topic, though, tomorrow night, so tune in for that, because unless something else comes along, I think that's what we're going to be talking about. Anywho, hour 2 now in the books of TCF Live on this fine Monday morning. It's so weird here in the Sonoran Desert. 5:30 this morning, my time, we started the pre-show and the sky's light already. It's so weird. Anyways, let's do this. Let's go to Texas. We'll say good morning to Judge West. Let's do that.
Good morning, you're Marquise Berry, and this is 25 DCCR 0882. Miss Berry is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, I need one more reset. I've got the paper discovery. I have visited with Miss Berry on the phone, but I need to get the media, I've put in the media request, but I just haven't received it yet.
Okay. All right, and if you'll check on that, Mr. Nicholas, if you don't mind, see where that is in the process, and we'll reset it so you can get that and get an announcement the next court date. Stay in touch with Mr. Radford so that when he does get that information, you can go in and visit with him and see all of that before that next court date.
Thank you, Judge.
Free to go. See, Mr. Price, on Dale Johnson, 3 cases. Okay. Okay, let me.
Judge.
Good morning, you're Dale Johnson. And Ms. Johnson's 3 cases are set for trial to begin with jury selection next Monday. What is the announcement?
The announcement is not ready, Judge. The defense was notified late last week by the state that the state's come into possession of some video files that relate to our complaining witnesses. As of now, the defense has not had access to these videos. I understand that they may be Brady materials, and in order to provide effective assistance, we need time to analyze these videos, Judge.
And if I may, Your Honor, they were unexpected. They were delivered to our investigator.
Go ahead.
who has been working to download them. And so that we can make them available both to Mr. Price and also to me. I don't know what the contents are.
And where did they come from? I'm sorry.
From the mother of the complaining witnesses. And so I don't know if there's Brady material there.
Yeah.
I don't know what's there, but out of an abundance of caution, I notified Attorney Price and we need to take care of that.
Okay, obviously, I let you guys do that, but if you'll let the family know, let everybody know, this is the final reset. Whatever comes up, these cases are some of the oldest on the docket, and they're going to go to trial the next time it's set. All right, everybody needs to be prepared. But I'll give y'all some time to get that taken care of, and so that you can go over it with your client, and then we'll see you back at the next trial date.
Thank you, Judge.
All right, you're free to go.
Thank you, Judge.
Okay, thanks. That's why we have so few on that one, because I think I'd especially, oh, well. Mr. Macon?
Yes, Your Honor.
You have Juan Martinez Rodriguez. It's a sentencing.
Yes, Your Honor.
Good morning. We need to get probably a court interpreter to go through all of this.
Okay.
I know we've used that, but I think for the plea, we used someone else, correct? We brought someone down here. You've come and tested and helped
Yes.
us interpret several times, but when we took the plea, actually last time we had someone else come help us, correct? Someone else came and did it. I don't. Can you see if Jennifer's available, please? Just because of the legal terminology on this one.
It was my brother, so when that came last time.
Okay, I just want to make sure we've got all the legal terminology down that I need to go over. If y'all will have a seat, I'm gonna get someone that can come interpret that works for the court, okay?
Yes.
Thanks. And then you have Fernando Flores, Mr. Makin's is sentencing also.
Yes, Your Honor.
Morning. You're Fernando Flores. And Mr. Flores, you were previously in court in cause number 25 DCCR 1231, entered a plea of guilty to abandoning or endangering a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your
Any additions or corrections?
Honor. No, Your Honor, not from state.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney. Defer all proceedings and place your probation for 5 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed and you'll never have a conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and sent to the state jail prison for between 6 months and up to 2 years. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir.
If I can.
Okay, thank you. Ms. Holmes, you have Carisha Mays. Is she coming down? Is Ms. Malfino coming down? What about Daryl Sneed? Are you ready on that sentence?
Yes, I don't believe he's here yet.
Daryl Sneed.
He didn't appear at his PS.
I'll take care of it next. Thank you.
While we wait for the next contestant, Barbara, thank you for the $5. Let's not forget that we also have the best host and co-host on YouTube. Well, I don't know about the best host, but with Ellie, you definitely have the best co-host for sure. But thank you so much.
Other side. But I do a forfeiture for him not showing up, even though there's already a warrant. I don't. All right, there was already a warrant issued for his arrest because he did not show up for the pre-sentence report. So we'll see if we can get him into custody and go from there. Yes, I am. Thank you. That's okay. Whatever y'all tell me to do on those. Mr. Macon on Juan Martinez Rodriguez. Good morning, ma'am. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes.
Thank you. And sir, are you Juan Martinez Rodriguez?
Yes, ma'am. Yes.
And Mr. Rodriguez was previously in court, entered a plea of guilty to theft of property.
Yes.
I've received the pre-sentence report and reviewed it. Have you both had an opportunity to review it?
Yes, Your Honor.
Mr. Nichols?
Oh, no, I have, Your Honor, sorry.
Are there any additions or corrections?
No, Your Honor.
Not by the state judge.
All right, sir. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 5 years. You're ordered to pay the $500 fine and follow all of the rules and conditions of probation. If you do everything you're supposed to on this probation, this is a great opportunity. Because you don't have a felony conviction on your record. If you successfully complete the probation, at the end of the case will actually be dismissed. If you violate any condition of probation, you can be brought back into court. You can be found guilty of the offense and sent to prison for a period of up to 10 years. Do you understand?
Yes, sir.
All right, I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you waived your right to appeal. And if you'll have a seat here in the courtroom, probation is going to call you to her desk when she's ready to go over your paperwork, and your family member can help you translate that. Okay, thank you. Thank you. Sir, Mr. Macon, I think they're ready. She's ready for me. If y'all want to go ahead and get the,
Thank you. Mr. Rodriguez.
You say your attorney.
Mr. Parker. Mr. Rojas, you have Terrence Currington. What's your name? Oh, no, you're going that way.
Not seeing
You
Mr.
can
Curran.
write
Terrence Currington. Terrence Currington. Mhm. Morning, Mr. Reynolds.
Good morning, Ann. Mr. Smith, Mr. Rowland.
Just having a large time today. Bond will be forfeited for non-appearance and reset at 100,000. Anthony McFarland,
Same answer, Judge, but I do have an offer that this,
Anthony McFarland. You want me to hold it?
yeah.
Okay,
Well, actually, we can. Yeah, what's all?
hold it.
He has a misdemeanor, we can dismiss it for a cleaner and a misdemeanor, but I need to talk to him about it.
Okay, let me hold that for a second. Just have a seat. Mr. Rojas will visit with you in a minute. And then Gabriel Pena.
He's here.
Pena. Good morning, sir. Are you Gabriel Pena?
Yes.
And this is 26 DCCR 0064. Mr. Pena is charged with failure to comply with sex offender registration requirements. And Mr. Rojas, what is the announcement?
Judge, we do have all the discovery. We have an offer in the case. As you can see, Mr. Pena's got some health issues. We haven't had a chance to get together and talk about the case yet. I'm asking for the reset so that we can do that.
Mr. Pena, I'm going to reset your case about 30 days. It's important that you make an appointment and go visit with Mr. Rojas before that next court date so that we can get an announcement on the next court date. Okay?
Yeah.
Thank you. You're free to go. Mark Ramirez, Mr. Rojas.
Mr. Nichols' case. We got any.
Good morning. Are you Mark Ramirez? And this is 25 DCCR 1362. Mr. Ramirez is charged with aggravated assault with a deadly weapon. And what is the announcement?
Judge, the complaint in this case has done the options class. I've chosen not to dismiss it. I had made an offer, or at least we discussed. Did I officially make an offer to you, Charlie, on this?
We did not.
I was going to offer a misdemeanor on it, and I think they need to discuss that at this point.
Do you want to hold?
If we can hold on,
that
it's
today?
just first I'm hearing about that.
It just wasn't
We
a
call it
dismissal.
Okay.
No, it's not our normal.
That's okay. That's up to you. I'm gonna hold the case and so y'all can visit this morning. Just have a seat. Mr. Rojas will visit with you in a few minutes. And then you have Darius Sparks, Mr. Rojas.
That's Ms. Malpino's case, Judge. She was gonna send a letter to the complaining witness.
Okay, let's see if they have any notes. We might need to wait for her. Is there a note in there? She was gonna, or do we need to wait for her?
She's next to the witness to send her a letter or something.
Let me just hold
He
it.
has tried correspondence and is not been successful. Just basically.
Is she's coming down
She
there?
is coming.
Let's hold it. Just have a seat until, your attorney can visit with Ms. Malpino.
Leave it, Barnhouse.
Is, Mr. Wasserstein
Yes,
here? Good morning, sir. On Guadalupe Reyes. Yes, sir. Morning, how are you? Good morning, sir. Are you Guadalupe Reyes? And speak up, please.
Yes.
Thank you. This is 25 DCCR 1422. Mr. Reyes is charged with aggravated robbery. And what is the announcement?
Judge, I tendered an offer this morning after speaking to Mr. Wasserstein a little bit about this case. Since our last appearance, I've made him aware that the co-defendant has pled and been sentenced to 15 years in the penitentiary. I've also provided a statement that co-defendant had provided to us, further implicating Mr. Reyes. And so I tendered an offer to him this morning, and I think they probably need time to discuss that.
Okay.
And then if they don't take it, it can be set for trial.
Right, this is gonna be the final reset. It's like you were hired early in November.
Yes, sir.
Some of these discussions probably should have taken place before the morning of court, but I'm gonna reset it, a normal reset, and then let's get an announcement one way or the other at the next court date.
Yes, sir.
Make sure you visit with your attorney before the next court date so you can go over everything with him and be prepared for an announcement, okay? Thank you.
Thank you, Judge.
Y'all are free to
Thank you,
go.
Your Honor.
Thank you.
Okie dokie, friends, let's change it up a little bit. Let's go up to Michigan. Judge Middleton, it looks like, is gonna do some misdemeanor stuff, I think.
All right, we're back. We finished our civil matters. We have 2 criminal cases, misdemeanors we're going to address. The first of those matters, we have Mark Wittenberg. Mr. Wittenberg is here with his lawyer, Mr. Knopfinger. Mr. Wittenberg has 2 separate cases. File 251382 SD alleges operating while with a high blood alcohol level on June 13th of 2025, July 13th of 2025. He is also charged with assault and battery and domestic violence in file 252588 SM. Mr. Knopfinger scheduled this matter for a plea this morning at 11 o'clock. He is present, also present is Abby Stoll from the prosecutor's office. So I understand that the plea that is scheduled is a plea to impaired driving and the operating while intoxicated charge 251382 and assault and battery in the domestic violence case 252588. Is that your understanding, Mr. Knopfinger?
Yes, Judge, and there's a HIDA component to the assault and battery, Judge.
All right. Abby, you concur with that offer? Two, 51382. Let's start with a drinking driving case first. It happened last July. It's a long time ago. The allegation is that on March 13th at 1 o'clock in the morning, you were driving a car in the city of Three Rivers with a high blood alcohol level. That is punishable by up to 180 days in jail, $750. Also carries 6 points and requires that your license be suspended. I'm trying to see what the blood alcohol level was. The prosecutor has agreed to dismiss that charge for a plea to impaired driving. Impaired driving is better for a couple reasons. the main reason it doesn't require the suspension of your driver's license. It would allow you to keep a driver's license to drive to and from and in the course of work, treatment, school, and other limited purposes. That's called a restricted license. The maximum fine would be $300 rather than $750, and it would carry 4 points rather than 6. It's also punishable by up to 93 days in jail. Do you understand that charge?
Yes, Your Honor.
And are you going to plead to impaired driving? Are you going to plead guilty to the lesser charge of impaired driving?
Oh, yes, Your Honor.
Anybody threaten you to get you to plead to that
No, Your Honor.
or promise you anything? I'm looking to see if I have any facts in here. I don't really have much other than a ticket. So let's look at the ticket. Were you driving a car at about 1 o'clock in the morning in the city of Three Rivers? Oh. We haven't fixed the other one yet?
No. Abby wants to get.
All right.
I apologize. I made you gotta fix it.
Okay, we'll figure it out. Were you driving a car at about 1 o'clock in the morning near downtown Three Rivers?
Yes, Your
That's
Honor.
close to where you live, is it not?
Yes, Your Honor.
Where were you going?
I went to McDonald's and then back, Your Honor.
We get lots of those. What had you been drinking?
It would be gin, Your Honor.
What did you mix it with?
Nothing, Your Honor.
Well, that's a red flag.
Well,
Gin and McDonald's sounds like a great combination. Juniper berries and French fries. What was the blood alcohol?
I don't know if you noticed, Judge, is a 0.19 BAC and breathalyzer was a 0.2.
All right, will you accept that?
Yes, Your Honor.
Abby, I've got your microphone. So will you accept that also?
Yes.
Well, this is a generous plea offer. It does resolve both cases. Do you still live above 60 North Main?
No, I do not, Your Honor.
We'll get your correct address. All right. We'll set both of these at the same time. I use this scheduling program 50 times a day. Judge Pattison doesn't use it at all. I don't know what I'd do without it. Luke, are you available on Monday, June 8th at 11?
Yes.
Tell you what, let's set these for 10:30.
Even better, thank you.
Mr. Wittenberg, did anybody promise you anything to get you to plead to this charge
No, Your Honor.
or threaten you?
No, Your Honor.
And you signed a waiver of your advice or rights. You understand you're giving those up by entering this plea?
Yes, Your Honor.
All right, let's look at the other case. In that matter, it's alleged that you assaulted either Madison Jackson or Gage Lee Knight. The assault and battery is on Gage Knight, who I think was a friend of your girlfriend, and Madison Jackson was your girlfriend. So the plea would be on count one, the
A and B,
A
Judge.
and
if
B,
that
and
is count.
dismiss
Um,
the domestic violence.
Yes, Judge.
Do you agree with that, Abby?
Yes, Your Honor.
All right, same rights apply. You're giving those up in this plea. Let's talk about the difference between assault and battery and domestic violence. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. But there is a special provision under the law which allows the judge to put you on a probation and defer the sentence. And if you successfully complete the sentence, the charge would be made non-public. It also would prohibit you from using or possessing a firearm for 8 years. Assault and battery does not have that firearm provision, but it also doesn't allow for a deferral under the domestic violence statute. So your lawyer is going to ask me to consider Holmes Youthful Trainee status. HYTA stands for the Holmes Youthful Trainee Act, which is a similar method of deferring a sentence with probation and having it taken off your record. I haven't made a determination yet. I'll have to look more carefully at it, but they're going to request that the matter be deferred. Is that correct, Mr. Knopfinger?
It is, Judge. Thank you.
All right. Now, I do know a little bit about this. There's a bond information sheet. Had you been in a dating relationship with Madison Jackson?
Yes, I was, Your Honor.
And were you living together at that apartment on North Main Street?
Yes, Your Honor.
And did you go there on December 16th and get into it with her, but more specifically with Gage Knight?
Yes, Your Honor.
Tell me what happened regarding Mr. Knight.
He opened my apartment door and my dog ran out, so he put my dog in his truck. Then I had my dog in my arms and then he pressed his
Was he inside your apartment or outside your
He
apartment?
was right outside the front door, Your Honor.
All right, where were you?
I was in my apartment, Your Honor.
All right, so he opened the door from the outside?
Well, I opened it to like tell him to leave because
Well, he was apparently concerned about the safety of your girlfriend.
I don't have a reason why he would be.
All right, well, so why was he there?
I couldn't tell you. He
All right,
showed
so
up.
you opened the door, your dog ran out. What kind of dog do you have?
It was a pit bull mix.
Of course. So he put your dog in his truck?
Yes, Your Honor.
Why is that?
That I have no clue, Your Honor.
All right, well, so then what happened?
I opened his rear door and got my dog, and as I was holding my dog in my arms, he pressed his chest against mine, so I pushed him back, Your Honor.
Well, here's what the bond information sheet says. It's about 9 o'clock at night on December 15th. This guy comes to your apartment. Somebody called and said, hey, these guys are fighting out on the street. Someone called the police. Knight told me he had come over to talk to his girlfriend, Madison Jackson. Knight told me that he heard a loud bang come from inside of her apartment. Knight told me that Wittenberg came out and started yelling at him after he knocked on the door. I went and contacted Jackson. She told me that Wittenberg had been drinking, that he was upset, so she locked herself in the bathroom. Now let's skip ahead too. Knight told Officer Candolph that Wittenberg had shoved him multiple times and attempting to get him to fight. When you were outside on the sidewalk level, did you, in this scuffle over your dog, push or shove Mr. Knight?
When I had my dog in my arms, Your Honor, yes.
All right. I'm gonna set this for sentence. That's a sufficient factual basis for June 8th at 10:30. Need victim input and police report. Don't tell me the address, but where do you live now? What town?
I have his address, Judge.
All right. Are you still in St. Joe County?
The past month I was with my aunt, Your Honor, but I'm staying with my dad currently.
All right. Is Miss Madison still in the apartment at 60 North Main?
No, Your Honor.
Okay. Well, I'm gonna have to get, are you and her still in a relationship?
No, Your Honor.
No. Are you on probation or parole anywhere now?
No, Your Honor.
Are you working someplace?
I'm currently looking for a place of employment, Your Honor.
All right, well, we'll find more about this. Assault and battery, as I said, is a lesser charge. You might get a probation anyway on the drinking charge, so maybe we can hope for the best. All right, I'm gonna have the bailiffs take you out to the court office and they'll get you your appointment regarding coming back in for the screening. And, oh, wait a minute, this goes with it too. I'll just give you this whole folder. Thanks. Thank you, Mr. Nelson.
Thank you.
TCF Live on a Monday with about 25 more minutes to go. Once again, the day moves by so fast, but thank you for spending your morning with me. Let's go back to Texas. We'll check in with Judge Stevens.
Ms. Broussard, is that you? Does she need to swear in or anything? It's a motion to revoke unadjudicated probation.
Oh, okay, yeah, no, I've already got.
All right. We can phone cause number 21-38622, the state of Texas versus Terry Broussard. You're Ms. Broussard? Yes, and you were here with your attorney, Mr. Dusler, and the state's attorney. There is a motion to revoke unadjudicated probation filed February 5th, 2026. Does the defendant waive a formal reading of this? Can we proceed in
Yes.
some?
Yes.
And also probation office is here and the state's attorney is here as well. Are you familiar with this motion to revoke unadjudicated probation, ma'am? Raise your right, you're nodding yes, so, okay, raise your right hand. There you go. You solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Right. Yes, sir.
In summary, this motion states that on October 13th, 2025, last year, in this court, you were placed on deferred or unadjudicated probation for 4 years for the Class A misdemeanor.
It shouldn't be. It should be state jail felony. Judge, I just noticed that when I was reading over this. I don't think Ms. Gonzalez caught it.
Yeah, I don't know. It was hard to be on probation for 4 years for a misdemeanor, isn't it?
Yes, it was a misdemeanor theft that was enhanced to state jail. There's a progress.
No, you didn't. And they just got it wrong on the motion. It's a state jail, or led to a state jail.
Yeah, look at judgment adjudicating guilt on October 13th of last year, degree of offense, state jail felony.
Yes, sir. It
2
should
years
say
state jail.
It should say state jail felony. I think Ms. Gonzalez just missed it on the motion. So we'd move to amend that from a Class A misdemeanor to a state jail felony.
Yeah.
It's like it was also
We've got
5 years. Yeah.
We've got several problems here.
Now, according to the judgment, on the adjudication, it says 5.
Bring it on. It's state. I think it's because she had some favors.
Actually, this, sentenced on 10/13/25, 2 years state jail, and then sentence confinement suspended, defendant placed on probation community supervision for 4
So
years.
this wasn't even a deferred, it was actual.
It's a regular probation.
Regular.
2 years, 2 years state jail, probated for 4 years.
Correct.
So we have to change a lot.
No, correct. Four is correct. Oh, except not overdue.
Yeah, right.
Yeah.
All right, this motion to revoke unadjudicated probation in 21-3863 has some errors. And in the second paragraph of the motion to revoke probation, it states that the defendant, Terry Broussard, a defendant in this case, was tried in the criminal district court, Jefferson County, Texas, on October 13th, 2025, for the offense of theft of property, a state jail felony. I corrected that from a Class A misdemeanor to a state jail felony. Any objections to that?
Okay.
It is corrected then. And that on such date, the judge of said court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt of the above stated offense, and then but deferred adjudication of guilt and placed the defendant on probation. Okay, that is incorrect. That phrase is incorrect because the defendant.
Yes. It should read, was found guilty and placed on probation. Just to 2 years state jail, suspended and placed on probation for 4 years.
See, here's the problem. You go back. This began as a deferred or unadjudicated probation.
Correct.
And it was deferred. She was placed on deferred or unadjudicated probation January of 2025 for 5 years. Then in 9-10 months later, motion to revoke probation had been filed. And then, then there is a administrative hearing in May of 25. Motion to revoke probation was to be filed. And
That's the correct language.
First, I cannot find the original motion to revoke probation here in this file. It's not in there. Can I get a printout of that? It jumps right to a judgment.
The one from 2005.
Yeah, yeah.
I've got a copy.
Well, let me get the one out of the bank. Yeah, because there's it's not in here.
There's one file, 8/18 of 25.
Yeah, there was a administrative hearing signed by the court to order a motion to be filed, and that was done on January 8th. That's what I have most recent. Then there was a order. Then in May 30th, an administrative order ordering the MTRP on May 30th of last year. And that, the next thing I have is a judgment adjudicating guilt. I don't have the motions.
You probably sent it for scanning. Let me, I just found you a copy.
Okay. I'm gonna do that. Walk this thing through on the red. Yes, ma'am. Thank you. Wow, something new here. Yeah. The court is now holding and will get this physically into the file. The file jacket here, and this cause number 21-38622, a motion to revoke unadjudicated probation, in this case filed August 18th of last year. And that resulted in a sentence hearing and sentence imposed on October 13th of last year. In this case, where the defendant pleaded truth to allegations 1, 2, and 3, failing to report to the probation office, failing to immediately report to the probation office her new phone number, and failing to provide verification of performing community service hours required, which were violations of conditions 4, 9, and 17 respectively of her deferred or unadjudicated probation order. The court found that was sufficient to revoke her deferred or unadjudicated probation. It was done. Then she was found guilty based upon that motion to revoke unadjudicated probation on 10/13/2025, sentenced to 2 years in the state jail, but that was suspended and she was placed on regular probation for 4 years. So the deferred converted to regular probation. And now here we are back for a motion to revoke. As it says, unadjudicated probation, but I've got to change that up at the top to regular.
Just move to strike unadjudicated.
Took out.
Okay.
All right, so again.
And after the word offense, this is the language, Judge, that we put in the motions I've got highlighted for you. You can add what you want, take out what you want, but.
Way too many words on that place.
Yes, sir. You could, like I say, you could shorten it however you want to, but. After the word offense, as that's where it begins. On this, I didn't change 5 to 4, but that's.
All right. This has been corrected here on the motion to revoke adjudicated probation from unadjudicated to adjudicated probation. And paragraph 2 goes on to allege that in a corrected form that Terry Broussard, a defendant in the above styled and numbered cause, was tried in the criminal district court of Jefferson County, Texas on the 13th day of October 2025 for the offense of theft property, a state jail felony, and that on such date, the judge in said court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the above stated offense, and punishment was assessed at 2 years state jail, Texas Department of Criminal Justice, suspended confinement, and placed the defendant on probation for a period of 4 years upon conditions that, and we pick up from there.
We have no objections to that amendment.
That is corrected and is all of that true and correct, ma'am?
Yes, sir.
All right. Allegation 1 states you failed to report to the Jefferson County Probation Office on or about November 12th, 2025, December 4th, 2025, December 18th, 2025, and January 8th of 2026?
Probably should be, Judge.
You should be, yes, sir.
In violation, okay, we're gonna correct that.
Yes, sir.
There's no end to the corrections in this one.
Yes, sir. Never made the homes you. All right.
And that is a violation of condition 4 of your deferred probation order. Is all of that true and correct?
Yes, sir.
Number 2 states you failed to immediately report to the probation office your contact information.
Judge, we can just call one. She's already agreed to the punishment.
Okay, 1. Are you pleading true to allegation 1 voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of 1 or more violations of probation? That's enough to grant a motion to revoke probation by a preponderance of the evidence or greater. The probation can hereby be revoked and you can be sentenced to no less than 180 days up to 2 years in the state jail. Knowing all of that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement has been reached here in your case where your probation would be revoked. And this is an agreement that you're agreeing to. Your probation would hereby be revoked and you would be sentenced to 18 months in the state jail, given credit for all time you have served in accordance with this case in confinement. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document? Understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered in without objection admitted. This goes on to state that you understand fully that you are giving up all rights of appeal if I follow this agreement.
Yes, sir.
I'm going to follow this agreement, man. Anything else to add by the parties? If not, I'm going to find that Ms. Broussard here in cause number 21-38622 has pleaded true voluntarily, knowingly, intelligently to allegation 1 of this motion to revoke adjudicated probation filed on February 5th, 2026, and as corrected today, as she was placed on originally deferred or unadjudicated probation for the state jail felony of theft of property. That was revoked. She was placed on regular probation thereafter. That was revoked hereby today. And her regular probation of 2 years in the state jail, probated for 4 years, is hereby revoked, and by agreement of the parties, the defendant is hereby sentenced to confinement in the state jail for 18 months. Do you understand what has happened today?
Yeah, 18 months, Joey, for.
And how much time does she have credit for? Do we know? We can give you an idea, because you're probably not adding all this up. And
She has time in other counties, Judge. I can't look that up.
yeah, you see, okay, we're not gonna be able to do it, but you are being given credit for time on this case for time you have served in custody in other counties. So it's gonna all add into the equation. You're not gonna lose anything. I know you may have to spend some more time. We don't know, but we can figure it out, but we can't do it right now. But it's because you were in jail in other counties, and we don't know exactly how much that is. But it will be added by law to your sentence, okay? Oh, good luck, ma'am. Thank you.
Okie dokie, friends, that will do it for this morning. Thank you again for joining me. I very much appreciate all of you. We'll be back tonight for In the Blind with Mike and Dan, 7 p.m. Eastern, 4 p.m. Pacific. Hang tight, because as soon as I end the stream, YouTube will take you over there so you can set your reminder. And then we'll be back tomorrow morning right here on this channel, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member for the pre-show. Thank you all again. I hope you all enjoyed the morning. I know that I did, and look forward to seeing you tonight or tomorrow, or hopefully both. Take care. God bless.